Open this hearing of the Parliamentary Joint Committee on Corporations and Financial Services. Today, the committee's inquiry and questions are on oversight of ASIC, the Takeovers Panel and the Corporations Legislation number 1 of the 46th Parliament. This is a public hearing and a Hansard transcript of the proceedings is being made. The hearing is also being broadcast via the Australian Parliament House website. The hearing will also be held virtually, with some committee members and witnesses joining by video link or telephone. If we encounter technical problems, the committee has the option to revert to using a telephone conference, and if necessary, all committee members and witnesses will be contacted by phone. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as contempt. It's also a contempt to give false or misleading evidence to a committee. The committee prefers all evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in private session. If a witness objects to answering a question, the witness should state the grounds of the objection, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. I ask everyone to ensure their mobile phone ringtones are switched to silent, and I'll do that now. And can I now welcome representatives from the Australian Securities and Investments Commission, and thank you again for appearing before this committee today. Information on procedural rules governing public hearings and claims of public interest immunity has been provided to the witnesses and is available from the Secretariat. Witnesses should speak clearly into the microphones, and if you're attending by phone, please state your name when you start speaking to assist the Hansard to record proceedings. To assist with the recording of this hearing, please ensure your microphone is set to mute when you're not speaking. For the Hansard record, could you please state your name and the capacity in which you appear? And having got through those formalities which our witnesses are well aware of, I'm going to invite Mr Longo, the Chair of ASIC, to make an opening statement.
Good morning, Chair. Thank you for that. Good morning, Chair and committee members. Would like to take the opportunity at this last hearing of the committee for the term of this Parliament to make some brief introductory remarks. I will summarise some key parts of ASIC's work in recent months before outlining ASIC's priorities in the year ahead. Starting with enforcement, between October and December 2021, ASIC completed investigations into matters arising from the Financial Services Royal Commission. Of the 13 referrals from the Royal Commission to ASIC, 1 is in civil litigation, 2 are under prosecution by the CDPP with charges laid, and 5 have concluded with no further action. 1 matter has received judgment with a $20 million civil penalty. 1 matter has received judgment with a $57.5 million civil penalty, and another matter received judgment with a $1.5 million civil penalty. And 2 other matters have received judgment with declarations made. ASIC has also successfully investigated and litigated a large number of the case studies explored during the Royal Commission. In October 2021, ASIC launched civil penalty proceedings, in the Federal Court against Insurance Australia Limited, IAL, alleging that IAL had failed to honour discount promises made to its customers. In November, we commenced 6 civil penalty proceedings against Westpac in the Federal Court in November 2021. The proceedings, each the result of an individual ASIC investigation, allege widespread compliance failures across multiple Westpac businesses. The alleged conduct occurred over many years and affected many thousands of consumers. It is unprecedented for ASIC to file multiple proceedings against the same respondent at the same time. Also in November, ASIC commenced proceedings in the Federal Court against ANZ for breaches of the Credit Act arising from referrals through its home loan introducer program and from unlicensed individuals outside the introducer program. We also commenced Federal Court civil penalty proceedings against MLC Limited alleging insurance policy and service failures resulting from poor systems and controls. In December 2021, the Federal Court ordered 4 companies in the Mayfair 101 group to pay a combined penalty of $30 million after finding the companies engaged in misleading or deceptive conduct and made false or misleading representations. The companies have appealed against these penalties. Turning now to regulatory efficiency. In November 2021, ASIC established a regulatory efficiency unit to promote better regulation by removing unnecessary frictions and making it easier for business to get things done. ASIC is meeting with a wide range of external stakeholders, including business, industry associations, academics, and other interested stakeholders who engage with ASIC. More than 70 external stakeholders have been consulted already. The REU will identify a set of initiatives this year that aim to improve the efficiency of ASIC's interactions with its regulated population. Now, I look forward to briefing the committee more about the activities of REU at future hearings. We are also working hard to assist the Financial Regulator Assessment Authority with its important work. ESG and crypto and cyber resilience have been 3 areas of focus that will no doubt remain of the highest order this year. On 14 December 2021, ASIC welcomed the establishment of the International Sustainability Standards Board. The ISSB will develop high-quality global baseline climate and sustainability disclosure standards to meet investors' information needs. ASIC released information for product issuers and market operators in October 21 on how they can meet their regulatory obligations for crypto asset exchange traded products and other investment products. The information covers good practices for market operators in how they admit and supervise these products, and good practices for product issuers in how they establish and operate these products. Key matters covered by the Good Practice Guide include admission and monitoring standards, custody of crypto assets, pricing methodologies, disclosure, and risk management. We released our latest report on the cyber resilience of firms operating in Australia's financial markets in December 2021. While the report has found Australian financial market firms continue to be resilient against a rapidly changing cyber threat environment, the improvement in their cyber resilience has been small. We've also been helping industry meet new requirements. Drawing to the end of 2021, we published information to explain how ASIC's regulation of the financial advice industry will be broadened now that the Better Advice Act has commenced. Furthermore, we issue information to explain the operation of the Financial Services and Credit Panel, whose role has been expanded starting 1 January 2022. We also gave an account of how the regulation and registration of tax financial advisors will be affected. Separately, we have taken over the administration of the Financial Advisor Exam from the Financial Advisor Standards and Ethics Authority, FASEA, which has now been wound up. We continue to respond to feedback from the financial advice industry on how to improve consumer access to affordable advice. On 5 November 2021, we released an information sheet on records of advice, which included 3 ROA examples. It clarifies the obligations of financial advisors and advice licensees when they use ROAs to provide personal advice to retail clients. In 2021, we reviewed the practices of the trustees of 5 funds that provided default income protection insurance on an opt-out basis to their members. The review again highlighted the need for trustees to examine outcomes for their members, proactively consider whether their income protection insurance products deliver value for money. In 2022, we will conduct surveillance on the progress made by industry more broadly in insurance in superannuation. As part of this work, we will ask life insurers for comparable and reliable data relating to income protection offsets. On 15 October 2021, we released updated information for employers and trustees on changes affecting the distribution of superannuation products as a result of recent law reforms. The information sheet provided guidance to employers on how to communicate superannuation choices to employees without breaking the law. In 2021-22, we will conduct a thematic review on how trustees use employers to distribute superannuation products. We will consider regulatory action where we identify misconduct causing consumer harm. Can I now turn to the Sterling matter? A few brief comments on Sterling. Late last week, the Senate committee handed down the final report in its inquiry into the collapse of the Sterling Income Trust. ASIC is considering the report's findings and recommendations, in particular, the two recommendations that are addressed to ASIC. The committee recommended that ASIC investigate and, if appropriate, commence legal proceedings against AFSL holders that are alleged to have breached Section 917B of the Corporations Act, but have not consented to participate in relevant AFCA processes. We are considering this recommendation. The committee also recommended that ASIC develop a framework to promote greater awareness and understanding among retail investors and financial consumers in relation to buying financial products and services. On this recommendation, we note that ASIC and Treasury already invest a considerable amount in financial literacy and consumer awareness work, including through MoneySmart. However, we are reviewing the financial literacy material in light of the committee's report, in particular in relation to supporting consumers having reasonable expectations of the regulatory regime and of ASIC. Turning to 2022, looking ahead, we are preparing our priorities for the coming financial year as we speak, and of course have established our corporate plan and have published our statement of intent. But there are some things that are a continuing thread through our work at this time. ASIC will be seeking remedies that deliver quicker outcomes in cases that are chosen more carefully, following investigations that are more timely. ASIC is also focused on raising awareness of new and continuing regulatory obligations. ASIC and the RBA, with the Council of Financial Regulators and ACCC, continue to closely monitor and engage with ASX on the CHESS replacement program, particularly now the program is in key testing and readiness phases. Work also continues on our internal priorities, including our digital uplift, improving our communication with stakeholders and other regulatory agencies, improving infrastructure and systems, better use of data, and cyber resilience. We look forward to taking the committee's questions. Thank you, Chair. Over to you.
And thank you, thank you, Chair Longo, for that comprehensive opening statement. I only have a couple of questions to begin with. I'll save some others for later. Two unrelated matters. You mentioned, with respect to cyber resilience, your comments there about and I'll just quote you, that firms continue to be resilient against a rapidly changing cyber threat environment, but the improvement in their cyber resilience has been small. Would you be able to, or one of your colleagues, just enlarge on that a little bit about how you see that going forward, the reasons for the improvement being small, whether that's a lag in what the firms are doing, what their plans are for the future, to the extent that you can tell us?
I'd be happy to assist, Chair. It's Kathy Armour, Commissioner from ASIC. In other, which we did, we focused on the cyber resilience of market participants mainly, so market intermediaries, investment banks. And what we found was quite interesting. We found that we've been reviewing the cyber resilience of these types of firms for a number of years now, and we found actually a bit more of a mixed result. We found that the smaller firms have actually been focusing really closely on their cyber resilience, and so they had improved their cyber resilience compared to the last time we looked at it, and we think that's partially because of the increasing awareness of cyber matters, but also because of the prevalence of cyber attacks that we've seen over the last few years. The larger firms, though, is the area of concern, because we found that there wasn't quite the same level of improvement. Certainly the firms didn't meet their own ambitions for improvement on cyber resilience. And we think what has happened there has largely been a change in priorities over the pandemic period. So I need to sort of address the immediate sort of technology needs, the growing sophistication of firms who may or actors who may look to challenge the technology that a firm has, and also we think there has been a real awareness that we still haven't all tackled as a community of the challenges for us of the cyber resilience or key third parties necessary for our business. And I think that is the area we called out that we think all firms need to pay a bit more attention to. Who do they rely on, and what is the cyber resilience of those folk?
No, thank you very much. And perhaps just at the start, do any members or senators have any questions on that issue, or no? Those online have any questions? Senator Scarr? No? And as I said, on an unrelated matter, to the extent that you can, could you provide the committee with an update on the Nuix matter from when we last met at the end of last year?
Yes, Chair. As far as the Nuix matter goes, it's now publicly been announced that we are not taking any further action in connection with our investigation, the forecasts in the prospectus, or concerns arising out of any conflicts that management and Macquarie may have done. However, on this subject, in recognition of the public interest and the committee's interest in this matter, I'm now going to hand over to Deputy Chair Sarah Court, who chairs the Commission's Enforcement Committee, and I'll ask her to introduce the response to that question, and also to introduce another colleague who we think will be of assistance to the committee, ensuring that there's a comprehensive and helpful response to any questions the committee might have arising out of Nuix. So, Sarah, please.
Thank you. And just before Sarah begins, just for committee members on this, once we've heard the response, we'll take some questions on this matter in particular, and then not revisit it right throughout the day. So for those online and those here, if there are any questions following Sarah's contribution, we'll deal with them straight away. So over to you, Sarah. Oh, she's got her microphone. You've got your microphone off. We can.
I'm so sorry, Deputy.
No, that's okay.
An auspicious start to the morning. So, Sarah Court, Deputy Chair. So, in relation to the Nuix investigation, as has now been reported, our investigation into the perhaps I should step back a moment. The committee will recall that ASIC is investigating various elements of conduct and concerns in relation to the Nuix float, and we discussed those to some extent at the last committee hearing. The first of those relates to an investigation into the release of the prospectus in late 2020 and the financial forecasts in particular that were contained in relation to that prospectus, and I'll come back to that. We've concluded our investigation into that element of the matter, and I'll return to that in more detail. The second part of our investigation is one in relation to insider trading of two individuals in relation to the various issues of Nuix, Stephen Doyle and Ross Doyle, of those individuals, and that investigation is continuing. And the third element of the work that we are doing, it's by a completely different team, is into concerns about potential breaches of the continuous disclosure provisions, and that investigation is also continuing. Turning back then to the question about the prospectus and whether or not we have are going to take forward any proceedings in relation to disclosures of the financial forecasts in the prospectus, whether or not the prospectus was misleading, whether or not the risks were sufficiently disclosed. We've done an extensive amount of work in relation to that issue over the last 7 or 8 months. The issue that we have had to grapple with or concern ourselves with is, was there a reasonable basis for the financial forecast contained in the prospectus at the time the prospectus was released in November of 2020? There were, of course, subsequent forecast downgrades issued in April and March of 2021 that those issues concern or relate to our continuous disclosure investigation, which is ongoing. But the Commission has decided this week that there is insufficient evidence to establish that there was not a reasonable basis for the revenue forecasts at the time the prospectus was released. I might pause there, Chair, to see how much detail the committee would like us to go into. We have a significant amount of information that we can give the committee as to what we've done in our investigation, and in broad terms what what the investigations were and what the reasons for the conclusion that we've reached. And as Chair Longo indicated, we have brought along, for the benefit of the committee, Natalie, who led the investigation in relation to this matter. So she has all the details at her fingertips, to some extent in the committee's hands as to the extent of the detail you'd like us to go into.
Okay, no, well, thank you. I just wanted to introduce the topic. I know some members will have some questions. I might go to the Deputy Chair who can kick off.
Thank you.
And then if there are other questions after that,
Thank you.
we'll deal with those.
Thank you, Chair. And as I said earlier, Senator O'Neill's unable to be here today, but she's sent me through a few questions that she wants answered on her behalf or investigated. And I'll basically read them. And I know you've explained a bit about why the investigation didn't go any further. But one of the second question is, what message does this send to other companies who wish to or engage in the same kind of misstatements on its prospectus, given the considerable issues with Nuix?
Thank you, Deputy Chair. I do think it's worthwhile just making clear that the issue of the prospectus has to be considered in accordance with the information that was available to the Nuix board and executive at the time the prospectus was released. In the previous 2 financial years, in the lead up to the prospectus, the revenue increases at Nuix had been, and I haven't got the precise figures here, but in the order of 20%. So 2018, 19, 20%, 2019, about 20%, give or take a few percentages. In the prospectus that was issued in late 2020, the revenue forecast was in the order of a 9% increase. And indeed, as I understand it at the time, there was even some commentary that revenue forecast may be conservative. Now, as things transpired subsequent to the issue of the prospectus, a number of factors contributed to resulting in revenue forecast downgrades in April and May of 2021. And we are considering, as I mentioned earlier, issues of continuous disclosure in relation to those issues. But where our investigation has concluded is that at the time that the prospectus was issued, that it could not be said there was no reasonable basis for those figures that were contained, and that is the legal test at the time that the prospectus is issued.
So, even though there was, forms of misstatements, is that okay on a prospectus?
I think, Deputy Chair, what I'm trying to get across, albeit perhaps somewhat clumsily, is that the benefit of a forecast in a prospectus is exactly that. It's a forecast. In this case, the revenue forecast contained in the prospectus was in the order of $193 million, and the actual revenue was in the order of $176 million. So there was a 9% revenue fall forecast as opposed to actual. And I think that the point that I'm trying to make is, with the benefit of hindsight, obviously there were misstatements the forecasts were incorrect, were proven to be incorrect, but the legal test looks at what were the facts and what was the knowledge of the board at the time that the forecast was released. And at that time, our investigation has concluded that the board and Nuix did have a reasonable basis for the revenue that was forecast in those at that later time.
Nevertheless, the amount of the forecast was quite substantial. It was around the 23 million, 24 million, I think, from the figures that you just...
The failure in the forecast, or the error in the forecast, the misstatement in the forecast, with the benefit of hindsight, was in the order of $17 million.
17 million. Still a substantial amount. It's quite a substantial amount.
Well, 9% of the revenue that had been forecast.
And the outcome of all of this, your investigation, etc., what policy changes will ASIC make following this particular incident? Have you looked at what I mean? And I think what Senator O'Neill's trying to get across, the occurrences that took place, will this make ASIC or yourselves look at the when investigating others in a different light? In other words, will you put changes in your investigations to make sure these forecasts, etc., are more accurate?
I think, Deputy Chair, I think Chair Longo will take this, but perhaps I'll just hand straight over to Deputy Chair, because that takes us back to this, I think, a policy question about what is ASIC's role when prospectuses are filed with ASIC, and that's been the subject of considerable discussion with the committee previously, and Chair Longo has dealt with that issue, so it might be wise of me to hand back to him on that issue.
And just as we do that, just before we come back to the chair, I mean, you've given us a great amount of detail on what the test is. So I suppose really the question, if you turned it on its head, is, should the test have parameters around it, which you could see being very cumbersome. So we'll throw to Chair Longo, but I can certainly see what the test is. The test at the time is what you're saying.
Thanks, Chair. The fundamental principles of an IPO in these circumstances are well established in Australia. They're very well established. So at the time of the lodging of the prospectus, ASIC's role, it's very well understood and established, and it's been the subject of previous evidence. It is not the role of ASIC to go behind forecasts or issues that are dealt with in the prospectus. I've gone over the test about that before. So, but to answer the second question about whether this incident or matter would raise any changes in approach, I think the short answer is no. It's very important to appreciate that the key principle, as the Deputy Chair confirmed, did the issuer, did the directors and their advisors at the time the prospectus was released to the market have a reasonable basis that the forecasts, the financial forecasts and other matters dealt with in the prospectus. That's the test. Did they have a reasonable basis? And what ASIC's comprehensive and thorough investigation I'm able to confirm, we're able to confirm, is that the directors and the issuer did have a reasonable basis for the forecasts that they made in November 2020. Now, it's only logical that those forecasts can only be based on information and analysis reasonably available to the issuer at the time the forecasts were made. And our investigation confirms that they were reasonable in that sense. Now, it should not come as a surprise when we have over 500 or 600 prospectuses are issued every year. We have a very active capital market, equity market in Australia, and investors know that things don't always work out the way people would like them to work out based on forecasts in the prospectus. And so that's what they are, they're forecasts, and provided they are reasonably based, then the Australian system permits them to be made. Now, the only other point I would make, and again it echoes what Deputy Port said, is our investigation on the continuous disclosure aspect continues. And can I just reassure the committee that that is a serious matter? Because what we're saying there is what that investigation continues, and the core issue in that investigation is once the issuer, once the directors became aware there was a change in facts and circumstances whereby the forecasts that were reasonably based at the time they were made in November 2020, when they realised that those forecasts could not be met, then under our system of disclosure, that has to be told to the market because that is a material matter. And the critical question in that investigation, and I will defer obviously to Sarah Port to give us more information, is did the issuer move quickly enough to inform the market of those change of circumstances so that original forecast could no longer be relied upon? And that aspect of ASIC's investigation continues. At the prospectus part, we are quite confident we've dealt with that very comprehensively. And Sarah has indicated, we're happy to take additional questions about, why we came to that conclusion. The key principle, reasonableness of forecasting, we concluded that the basis was reasonable at the time.
Look, at the time of the lodging of the prospectus, had you received any advice that warned the financial statements were not quite sound?
I'll take that question, but again, this was thoroughly dealt with. Can I reassure the Deputy Chair, and this question has been the subject of multiple questions of notice and earlier evidence, we did take into account in real time what the whistleblower had to say at the time the prospectus was issued. We are satisfied, I am satisfied, that all the policies and procedures of ASIC in connection with lodging the prospectus were followed. That evidence does not change. I can reassure the committee and Senator O'Neill that issues raised by the whistleblower were among, indeed, a range of matters that ASIC looked at in connection with the prospectus. So I'll go back to Sarah and Natalie to deal with that aspect, but I can reassure the committee it was what the whistleblower had to say and indeed fully cooperated with us, was fully investigated and taken into account. But I really do need to turn over to Sarah and Natalie.
Just before you do, just for the assistance of members and senators, and this is just a procedural aspect I'd like to insist on really. There have been a lot of questions that have been asked and answered on notice. They are on the public record. I don't want us to get into a system where lots of questions are asked on notice. ASIC work to get them answered. They're answered. They're there on the public record. They can be looked up to then use the public hearing to air what's already public. So let's. I know there can be a difference between the houses on these things, but let's just not have needless repetition. I hope that's clear enough because we've got other issues to get on with.
Just a couple of more questions from Senator Deb O'Neill, two more. And the second to last one is ASIC still examining the transfer of wealth following the release of the escrow period. And
Sorry, Deputy Chair, you might need to explain that question for me.
but as I said, I'm relaying him on behalf of Deb O'Neill.
Yes, sorry.
Perhaps we can, maybe you might want to take that one on notice. Is
Deputy
assets,
Chair, if it's all right, because I know Senator Neal was most concerned that we didn't take anything on notice, but perhaps with your indulgence or the Chair's indulgence, I can find an answer for that in the course of the day and come back to you.
I might liaise with her a bit later. And the last one is, would the market have confidence in your oversight, given that this enormous failure of oversight led to a bloodbath of shareholder capital? That's the last one.
Thank you, Deputy Chair. We would reject the assertion that there was a failure of oversight in this matter for the reasons that we've talked to the committee about on several previous occasions, and the issue that Chair Longo has just talked about. I think what the public can have confidence in is that in relation to the issues that the float of Nuix has caused, we have very intensively and systematically and quickly done an extensive review of the information that was available to the board and to the executives of Nuix at the time the prospectus was released. That's involved several meetings with the whistleblower. That's involved sort of a large number of compulsory examinations where executives of Nuix and their advisor, PwC Securities, have been subject to compulsory examination. We have issued statutory notices and reviewed in great detail thousands of documents that were available to the Nuix board at the time that the prospectus was released, and we have engaged with experts in relation to our conclusions on these issues. And we have done that in a fairly truncated period of time, given the complexity of the issues involved. And the Commission has formed the view that, as I say, in relation to the issue of the prospectus, there is not a case to be brought. But as Chair Longo and I have both said, we are continuing to look very closely at continuous disclosure issues. We have not given Nuix a clean bill of health at this stage. We are simply ruling out one course of action and continuing our work in relation to this very significant set of issues.
Thanks. And I'll liaise with Senator O'Neill about that previous question as well during the course of the day.
Okay.
Thank you.
Thank you. No, thank you very much for that update. We'll now change topic. I think I can see Senator Scarr there. Can you hear us?
I can.
Where are you? You're in Brisbane, are you?
Yeah, I'm in Brisbane.
Okay, all right. So we might go to you on the ASX matters, and Mr. Hill will have some questions as well. So we'll start with the two of them so that, again, we're not being repetitive. And if anyone else has got any other questions after that, we can ask them, but they've sort of occupied this piece of real estate for a period of time. So we'll start with Senator Scarr.
Okay, thank you very much, Chair. And at the outset, can I thank ASIC for all the work it's been doing in relation to the CHESS replacement project in particular. And Chair Longo, I noted your comments in your introductory statement. I was very pleased to see the ASX actually released a redacted, and I should say I think it was, from what I could see, appropriately redacted version of the independent expert report into the November 2020 outage. And I think that principle of transparency is going to be very important as ASX implements the CHESS replacement project. What steps is ASIC doing to promote that continuation, which I see as a positive development of transparency and making sure all relevant market participants are informed as to progress in relation to the CHESS replacement project.
Well, thanks, Senator, for that question and more generous remarks. I'll ask Commissioner Rama to give you a bit more detail. But as the market is aware and as the committee is aware, from my perspective and the Commission's perspective, the transition, the new system of CHESS next year is of the utmost significance for ASIC, and we are in continuous engagement between ASIC and the ASX and fellow regulators to ensure that the CHESS replacement is a success. So I can reassure the committee that engagement, oversight, communication is actually continuous, it's daily. And I think that gives the Commission some confidence that we're very aware of what's going on at ASX and what the issues are or challenges they may be facing. And I think that certainly contributes to the transparency that you very rightly highlight. But I'll ask Commissioner Rama to give a bit more detail about the industry engagement we do, communication with market participants and operators, a whole range of touch points that I think go to your question. So, Commissioner Rama.
Thank you. I guess the first thing to mention is the licence conditions which have been imposed in relation to the ASX outage have been imposed both on ASX in relation to its trading market and the two ASX entities involved in the CHESS replacement project. And as part of those conditions, an independent expert has been appointed to review and provide assurance on aspects of the project that really relate to some of the issues that occurred in the ASX trade outage. And I think one of the key points that you're raising, Senator, is the transparency of the reporting by that independent expert in relation to the ASX clearing and settlement entities that are subject to those licence conditions. And we think that's a very good point. We have highlighted and required flexibility in the appointment of the independent expert for market transparency on the reporting, and that's something that we will work with the relevant ASX entities and the independent expert in connection with that. And then I think the second element of the question really is an important element because the CHESS project is now at the first stage of industry testing, and which is involving testing by software firms that participate in the industry. But the next phase will involve testing with participants in the markets who really are very dependent on the effectiveness of the system for their day-to-day operations. And so it's going to be critical that we have really good lines of communication, both from the ASX and those market participants during that period of time, and also that we as regulators hear the diversity of views on how that process is going. The ASX has had quite an established stakeholder engagement program, and we have attended some of the meetings of one of the key committees regularly to observe how that program's going, and we'll stay close to those established programs. But I think the important thing for us to also do and to do with our co-regulatory agencies, the RBA, is to think about also whether there are other voices that we need to hear that aren't contacting us directly, and we'll think about making sure that we're doing that in an effective way as well, because I think that's going to be quite a critical element to getting feedback as that testing program goes.
Okay. So, I mean, Commissioner Armour, that provides a lot of comfort to me, and as I said, I'm impressed by ASIC's actions in this regard. If I could try and draw you out in some particulars, with respect to transparency. We'll see how we go. So if I read the particular licence conditions, for example, one condition is that the relevant licence holder has to appoint an independent third-party expert who assess the assurance program for implementation of the CHESS replacement project and oversee the implementation of any remedial actions arising from the IBM review recommendations, and provide the licensee and ASIC with the following written reports on the CHESS replacement project program and the CHESS replacement system. Roman 1, by 15 February 2022, which is only 4 days away, a report on the design of the assurance program, assessing whether the existing plan is fit for purpose, identifying any topics that need further independent assessment, and proposing any remedial actions. End quote. So it seems to me that's a key report. That's going to be the first, as I read the conditions, the first report which is provided by the independent expert under these conditions, basically saying where are we up to in relation to this project in terms of the assurance program, in terms of identifying any further topics that need independent assessment and proposing any remedial action. And that seems to me to be, given its importance, a report which should be made transparently and provided to all stakeholders so that they have an opportunity to assess whether or not it reflects what their perceptions are with respect to the status of the project. So could you inform the committee as to what's proposed in relation to the transparency of that particular report, which is due to be provided on or before 15 February?
So, Senator, I think what I would say is we'll make an assessment. We hear the strong point you're making, but we'll make an assessment with the independent expert about the degree of public production of the report. We can, of course, insist on everything being made public. The difficulty is there is a balance there between providing material, detailed material that is actually not useful to the public, and providing useful material which does, as you say, give the sorts of assurances that people will need to see. So I think your point is well made, and we completely see the value of the transparency, and that is the inclination that we have as well. But we do need to make an assessment depending on the issues that are being considered. And in relation to this project, can I just say there are a myriad of processes that have been underway for some years now, where the actual market participants are getting a degree of transparency. There are technical working groups that have been set up for a long time. So it's really, I don't think there's any lack of interest in transparency or bringing the market together. And it is going to be making sensible judgment calls so that people do get the good information they need about how the project is going, where it's at, and where gaps are in the most meaningful way, and we'll do our best there.
Right. One of the concerns I have, Commissioner Armour, is given this report needs to be provided by 15 February, so it's only 4 days away. Simply, ASIC hasn't received the report yet?
I don't know the answer to that, Senator. I'd have to go back and speak to the ASIC teams.
Okay, but you're not aware that you're not aware it's been received, so.
I'm not aware, no.
That's fine.
Yeah.
And I wouldn't necessarily expect you to be aware at this point in time, right? So it's 15 February. But one of the concerns I have, and I'm just saying this subjectively, giving you my perspective as I was listening to your answer, is when you're qualifying whether or not the report is made transparent or is provided to the public or to the market participants in particular, as being a subset of the public, and you're saying, well, we'll need to assess that. It's almost as if whether or not it is going to be made public is dependent upon what's in it. And I'll just expand what I mean on that and give you an opportunity to respond, because I can see you're wanting to respond. But I guess one of the concerns I have, and I'll give you a chance to answer this fulsomely, is we want to see it warts and all, right? It's if it's a bad report, if it says, look, there are substantial concerns, there's a lot of work that needs to be done, it's perhaps even more important that it's provided on a transparent basis. And the second limb of that is, I think it's incredibly important that for the market participants to be able to provide their input in a meaningful way to ASIC, and you've talked about the steps you're undertaking to get that input from the market participants, that they actually know what the ASX is telling you and what the independent expert is telling you. So they can actually provide an important reality check as to whether or not it conforms with what they're seeing. So if you could address those two issues.
Yeah, look, I hear the concern that effectively reports might be sanitised, if you like, or public information sanitised so the full picture's not getting out there. That is absolutely not our intention. Our intention is to ensure that where there are issues and concerns, that it does get out there. That's the whole point, and that those issues are identified and elevated as quickly as possible so that they can be addressed. So that I think that's our intention. What we're not interested in doing is having unhelpful debates about minutiae in the report that is not necessarily going to be relevant to the question about whether there's an issue or not. And so, and in particular at this stage when actually testing with the participants hasn't even begun, that may not be a constructive use of the ASX or the participants' time. So that's the sort of thing we want to do. We want absolutely make sure that the thrust and the key issues are highlighted, and that there's transparency about that. So we're very keen to do that, and that is what we're focused on. But it's a technical project.
That's right.
And so there is a bit of a balance there, and I don't think there's a lot of benefit in us receiving reports that are for our supervisory purposes that are written at such a high level that we don't get the accurate picture. So that's what I think we need to get a bit of a leeway for. Yeah, that's all. But I hear your point. It's very well made. We do not want to be involved in sort of painting a picture that's not accurate.
Oh, and I'm not suggesting in any way you would.
That, but you are highlighting for us the risk of a perception of that occurring. We don't want that to happen.
Yeah. Can I then move on to another issue in relation to risk mitigation? And that is, this is a huge project. It goes to the heart of one of the most important pieces of our financial markets infrastructure, and it is infrastructure and it should be seen that way. As I understand it, there's going to be a key weekend in April, next weekend, next year, when there'll be lots of people on the edges of their chairs, watching it very closely, including many of our friends from ASIC, I'm sure. What is being done to address the risks potentially associated with an unsuccessful cutover or changeover from the old system to the new system to ensure that there's no market interruption or outages?
Yes, Senator. So it's a very important question, and the ASX's project plan builds into it at least 3, I think, but I can double check that. But at least numerous whole of industry tests of the project, so that there are numerous dress rehearsals, and we think that's really critical. We will be doing our own scenario testing about what we will do if there are issues, what sort of issues there may arise, and we'll be continuing to have conversations with the ASX about the various the various scenarios that could arise, and make sure that we have and they have developed sort of plan Bs for if those scenarios arrive. But it is a really key question and a key area for industry, the ASX, and for the regulators.
Okay, and just sorry, Chair.
Yeah, I was just going to take Commissioner Armour's response a bit further. We're February 2022. This is happening about 14 months or so from now. The technology has actually been built. And I think it's really important for the committee to appreciate that as we speak, and as Commissioner Armour's explained, that they're testing as we speak. For the rest of the next 14 months are going to be spent testing the system and ensuring that it can actually work when they switch it on. And as Commissioner Armour says, the question you've raised is really the ultimate question. When it is switched on the critical weekend, it works. So what I was going to suggest to the committee is, as we get closer to April next year, the strategies and around risk mitigation, to use your expression, Senator Scarr, will be more detailed, they'll be more advanced, and I think we'd be quite happy to come back to the committee and give more information, or as much as we can say, about what steps are being taken by the ASX sure that it all works. But we're 14 months away. There's a lot of testing to be done between now and then. That is the crucial question, that when it's switched on, it works.
Okay. My last question before, through the chair, Mr. Hill is provided with an opportunity to ask some questions on this topic, is ASIC's capability. So I was reflecting on the role of the Financial Regulator Assessment Authority, which is the new authority which has been established, and it looks at both the effectiveness and the capability of ASIC, which led me to think, in terms of this space, whether or not, Chair Longo, you're satisfied that ASIC's got the relevant capability. And I know I'm impressed with the capability of all of our friends from ASIC, but this is such a technical project and of great of substantial importance. I would, if I were a commissioner of ASIC, I would have no idea. I'd be grappling with the technical nature of the project and struggling as to whether or not what I was being told from a technical aspect was correct or not. So the question I have is, from your perspective, Chair, are you satisfied you've got the capability within ASIC now, at this point in time, 14 months out from go live weekend, or you've got access to that through contractors or independent experts?
It's an interesting question. I'll let Treasury and FRA deal with the FRA part of your question, but from my perspective, there are several key points. The first is it's actually ASX's responsibility to get this right. And as Commissioner Armour noted, they've been at this for years. They are a world-class stock exchange and have been a world-class leader in the use of technology, have been for a long time. This CHESS replacement using distributed ledger technology and blockchain is It's a bit of a first, so we should all be quite proud of that. This is a very ambitious project that will enable critical infrastructure to be even more efficient, to be more resilient. It has a lot of benefits. I'll leave it to the ASX to sell it, but the point I'm trying to make is ASX, their responsibility to make this work. Secondly, within ASIC, I can reassure the committee we have a very deep bench of experience. People like Kathy Armour, Greg Yanko, Nathan Bourne, and the rest of the team have a very deep knowledge and understanding of how our markets work and the criticality of this technology. So I think we work very close with the ASX and market participants. So that gives us the capacity to understand the issues and the challenges, because we are very engaged with all aspects of the market. The third part of your question is a very interesting one, and that goes to technology. So we're the regulator. What makes us think we can understand what's going on? I think, again, I can reassure the committee if there's one project that, maybe just reframe that. I've never seen as many experts focused on a project as this one. Must be at least half a dozen world-class experts and consultants that are either working for us or working for the ASX. And so there's no shortage of technological expertise being focused on this. And in fairness to the ASX, we have total transparency into all of that. So it's open book. There's a lot of cooperation between ASX and ASIC about what's going on. We can, if we don't understand something, we can speak to their consultants, or we can speak to our own. And as Commissioner Armour reminded the committee, we actually have that capacity, indeed, just through the licence conditions. But so I think they're the three key points. That last one, there's a lot of transparency and communication and cooperation among the experts that are working on this. So from my perspective, I think that's a good combination that should give the committee confidence that ASIC does have the resources and the capability to supervise ASX.
Okay, well, look, I congratulate you, Commissioner Armour, on the work you're doing on this in your team. So thank you very much, Chair. Back to you.
We'll just cross to Mr Hill.
Thanks. I might just clarify a couple of things on the topics that Senator Scarr's raised, and then just add a few other topics. So just firstly on the stakeholder engagement, earlier on in the discussion, Commissioner Armour, you mentioned that you attend some of the ASX technical working groups and kind of keep an eye on their engagement. Do you have your own direct discussions with key stakeholders or market participants about their perceptions and views of the project?
Yes, we do, in the sense that we have an ongoing engagement program with market participants generally, and this project being such a key element for the market comes up as part of that engagement. So we will highlight issues, or we will hear from the participants about the issues they're having with the program. I think, though, and I know we've discussed this before, I think the point that we've been reflecting on over the last couple of days is, as we go into the industry testing with the market participants, whether there's more that we can do to chat, particularly with the participants who wouldn't necessarily come and talk to us, or who don't regularly attend one of our general market forums, which would tend to be the bigger participants. So we have been reflecting on whether there is more opportunities for us to reach out to some of those folk as they start into the industry testing program. I think it's probably the opportune time to do that.
I think it'd be of comfort, certainly to me, and I suspect others, if, to use a word you might have used before, there was a more structured approach to that now in the next phase, to make sure that the quiet voices are being heard, and also that there's a degree of confidence and rigour, not randomness, about who you're hearing from. Certainly members of this committee I know have received confidential information and approaches from people, major market participants, that are very concerned about the delays, about the cost, about the ambition. And I think, as Chair Longo observed this is a world first and we should be very proud of it, provided it works, and we won't really know that till April. Otherwise, it'll be the subject of books and articles and things like the London Stock Exchange one when it blew up for years to come.
Someone else will be chair.
Someone else will be chair then. That's one thing we do know. It's been described, I think, as a big bang approach to phase it in over the weekend, and you've touched on the risks there. In terms of, I think, Chair Longo, you suggested that the committee could do a bit of a deeper dive into the risk management and the Plan B options later in the year. That might be something
Yes.
which the new committee
Well, I
might
think
want to... Sorry, go on.
I can understand the significance you're placing on the CHESS replacement. It really is a major priority for ASIC to make sure this gets done properly and it gets across the line. Although having heard this discussion, I wonder whether I should be on some remote mountain that weekend. But can I just reassure the committee that this discussion is really helpful and appropriate? I think the idea of, and as Commissioner Armour put it, we see opportunities for more structured communication. Something with respect you just mentioned, perhaps offline in an appropriate way. If committee members are getting, information or communications that are concerning to you that we haven't dealt with already, then I really do invite committee members to let us know, and we will, confidentially in an appropriate way follow up those concerns, because I think there really is a lot of goodwill at ASX, at ASIC, and in the market for this to work. I mean, it's in everybody's interest to work.
Yep, no, not questioning that. Is it within the scope of the independent review of the independent experts' work to examine those fallback plans or failure plans for the project? And are you confident the independent experts also been speaking directly to market participants about that?
So, Mr. Hill, the independent expert was appointed, I think, the 22nd of December or some period there. Yep. So they've had a limited opportunity to have those conversations. They are at this stage looking at the assurance program, and we will get the sort of plan as Senator Scarr pointed out. We'll get that in the coming days. So points you raise are points we will absolutely think about in the context of that, of looking at that plan. But I did want to point out the ASX has in place a number of third-party experts with who have technical expertise in a range of matters relevant to the project, and the regulators, and that's principally ASIC and the Reserve Bank, have been following and receiving, following the reports of those experts and the work of those experts, and receiving information about those experts' conclusions as we've gone along. So it is something that that we and the ASX are planning for and looking at.
Can I just put a couple on notice? I'm just in the interest of time floating through. You had an earlier discussion about transparency in the reporting, and I think that was a sensible discussion. Can you just take on notice, I may have missed it, to provide the committee with advice on which expert is being used for the review and what their technical qualifications are to do the work and what the full scope of the review actually is? Because I think the discussion before about transparency focused on this next report. This is a slightly different question.
Happy to do that.
Thanks. It's just about confidence in the record. And you answered a question from Senator Scarr about international standards and experience, and I'll just read it quickly. You pointed to this must be catchy document for my insomnia, if nothing else, Principles for Financial Market Infrastructure and the roles that the Committee on Payments and Market Infrastructure and the International Organisation of Securities Commissions play. So we acknowledge those standards. Can you just take on notice whether you're satisfied that the CHESS replacement program is indeed consistent with those international principles which you pointed to? Oh,
there were one of the regulatory. Sorry,
That's okay.
one one of the regulatory requirements is that this particular financial market infrastructure meets the a range of
Yep.
Standards. So yes, we're happy to provide that confirmation.
Okay. Some of the concerns that we've heard relate to, I suppose, accumulated and ongoing frustration about the extent of time that this project has taken, the fact that it's climbing north of, I think the official cost is around $250 million for effectively a new software system. I don't mean that in a diminishing way, it's a very complex endeavour, but that's in essence what it is. But that cost doesn't in any way count the enormous costs of market participants in rebuilding their own systems. And as has been pointed out, as the time goes on, particularly in this phase of the project, the opportunity cost for senior people in all sorts of companies getting chewed up with technical working groups and so on. Is the business case for the project itself, given the number of years that this has dragged on, is the business case outside ASIC's scope of responsibilities, and is it in any way relevant to the work of the independent expert, or that's a matter for the ASX and the market participants?
So the obligation on a settlement provider is to have a fair and effective settlement system from our perspective, and it needs to meet the financial stability standards. And when you have a system that is quite aged, well over 25 years, I think, in the current system, that actually imposes everyday costs on market operators because of relies on quite extensive messaging arrangements that isn't against the possibility of a modern contemporary system that meets the contemporary messaging standards and could provide a platform for great efficiencies.
I'm not, sorry, maybe I should have
Market
been...
participants.
Yeah, perhaps I should have been slightly clearer. I'm not questioning the fact that a new system is needed, but the need for an upgrade was agreed in 2015. This project was launched 2 years later. If the current go-live date happens on the weekend that Mr Longo's going to his mountain next year, that'll be 8 years after the need was first identified. Every other stock exchange in the world that's upgraded its systems, the advice I've received, has taken 2 to 3 years to do a complex project. So there's certainly a business case question there for some of the market participants saying, well, we need a new system. This one's gone on for 8 years. We keep investing more, and every time delay and now the intensity of the testing is taking a hell of a lot of their time. So I suppose I'll leave that, and you might provide any further responses, but is it within the scope of your work or the independent expert, given the accumulated frustration of many people in the time that this is taking?
I think, Mr Hill, the frustration may be for many market participants in that there's been a general technology refresh at the ASX affecting almost all of their systems and their trading platforms over the last 5 or 6 years, not just necessarily the CHESS system, and that may be what's feeding into some of the frustration that you're hearing. The market participants are really having to engage in the big time constraints, time issues for them are coming up now in relation to the CHESS program. So it may be the cumulative effect of that change out that is perhaps fueling some of those concerns.
Well, they might be issues you can explore in your structured stakeholder engagement as well. The final set of questions, I'll just note the news announcement that the CEO of the ASX has decided to retire or step down from that role in the next little while. Is it unusual, or in your experience, to have a CEO change at such a crucial stage of this CHESS replacement project, who will be out the door before the go-live date? I just wanted to firstly just check whether you have any comment or view on that general issue, and then just a couple of specific questions.
I don't have a particular comment on the general issue. My understanding from the market announcement yesterday is the CEO has announced his intention to resign so as to give an opportunity for time for a replacement to be put in place. He's not going anywhere right now. He's not going off to another job. He's staying and energised to do his job for as long as required. And as the chair pointed out, the system has largely been built. We're into this testing phase. So I think there's a bunch of other considerations which, I mean, the ASX can speak to themselves on that. Okay.
And I'm not trying to have a gratuitous crack. I think given we're here in the scale of the projects, they're a reasonable set of questions. In the less than 12 months, the original architects have left the ASX, the former chairman, the former deputy CEO, the head of the project, and now the CEO. 6 months ago, the RBA put the ASX board on notice for their lack of, for the issues in the project as well as the trading failure. And then 3 months ago, you put in place fairly pointed licence conditions around the CHESS replacement project, which we welcome. So I'm just checking whether there's any impact on your confidence in the project from what you know of the announcement that the CEO is departing. And the answer may well be no. For example, he's still on board doing his job, presumably well, but it's a reasonable question whether there's any impact on your confidence or view of the ASX given those departures.
As you've said, this is a project that has gone, was first announced a number of years ago. One would expect there are changes in a corporation over that time. Actively monitoring and supervising this project along with the RBA, and we're providing feedback and input on how that project is going to the ASX and making clear what our expectations are. All our conversations with the ASX, particularly at board level, indicate they share the same ambitions and expectations that we have.
Okay. And there's, in terms of the licence conditions, were there any personal attestations required of the ASX CEO in relation to those licence conditions?
There are attestations required. I would have to, I apologise, I'll try and check while we're in session today to see if there's anything personal required of the ASX CEO.
Okay, and just whether there's any implications, obviously, that they may need to be refreshed or renewed as a transition occurs. I think that's probably all I've got. I mean, I do note the Fin Review's commentary in the last couple of days around the timing and the impacts on market participants if the timing is extended from April the 23rd. But I suppose that's an issue that the committee will remain interested in, as will ASIC.
Yes, at the project timetable is a really important issue, which we are all actively following it.
Yeah, well, look, at least to my mind, you know, if I end up here again after the election, given it's our last hearing, I think the chair said he's going elsewhere. Might meet him on the mountain somewhere, Chair Longo.
I'll still be here.
You'll still be here, yeah, you'll still be here, you'll fly the flag.
Term.
Yeah, well, all right, Senator Scarr, on all of our behalf, I think.
Just before we leave the topic, I just did want to flag, I just got a note from our team. The independent expert, just on that first report, has asked for an extension till the 28th of February. So it'll be later this month that we receive that report.
Busy Valentine's Day, I suppose. That makes sense. Well, it's an issue, I think, that, you know, those listening at home could expect, if I can divine Senator Scarr at least, I think he and I have a similar mind on this matter, that certainly the successor committee, I would expect, would take a strong public interest in this and may want to hear on the record from the key actors and participants and stakeholders perhaps in the third quarter this year. After the election. I think the project is of such import to the Australian economy that the Parliament needs to get people on the record with these assurances and understand a little more about the risks and what happens if things get delayed further.
And
Particularly useful once there's been a decent amount of time for industry testing. I think that would make it most useful, yeah.
of course, we've got the capability to make commentary and recommendations in our report.
We do.
To Parliament. So
That's good, isn't it?
That's why we're here.
Yeah, one of many reasons.
That's right. That's right. So, look, thank you for the questions, Senator Scarr and Mr. Hill, and thanks for the answers and for the commentary as well, the discussion, the broader discussion. So, it certainly is the case. I'd like to make the point that the oversight function obviously goes to, specific questioning, and we're very familiar with that, but also just a broader discussion is also important for the oversight function. Look, we are just 5 minutes before the scheduled break. We will go to Senator Pratt next. I think in the interest of efficiency, we'll break now so that we're not cutting you off, Senator Pratt. We'll resume in half an hour, if that's okay. So at 5 to 11. I'd like to...
I'm very sorry to interrupt you, Deputy Chair. It's Deputy Chair Cord.
Yeah, sure.
There was, just in the interest of efficiency, I am able to respond to the Deputy Chair's question in the Newix matter, and I just wonder if I might get that answer on the record now before we break.
Yes, yeah, because we don't want to keep revisiting the same topic. No, so thanks.
So, Deputy Chair, as I recall it, the question that Senator McNeil requested that you ask is whether ASIC is still examining the transfer of wealth following the release of the escrow period.
Correct.
So the short answer to that is that we are not. So these voluntary escrow arrangements are a voluntary agreement, a commercial arrangement between the security holders and the company. They're very common in IPOs of the size of the Newix float. They're not mandated by law, though, and ASIC doesn't have any power to require parties to enter into those arrangements or indeed to maintain them. And importantly, in relation to the Newix prospectus, the escrow arrangements were disclosed in the prospectus, and we did analyse that as part of our investigation. So the short answer is that we are not continuing to look at that issue. And just while I have the floor, Chair, there's one other thing I should just correct. I can't quite recall the figures that I got, but just for the record, the Newix prospectus forecast a revenue increase of 10%. I may have said 9% in my answer.
Yeah.
And the actual deficiency ended up at 9%. So forecast was 10% increase. The actual revenue was indeed a 9% decrease. And my final, and I hope this is not inappropriate, but Ms. Durr, who is the lead investigator, Chair, has come along to the committee because we were keen that she'd be able to assist the committee on the details of our investigation into Newix. If we are not going to revisit that topic for the remainder of the day, I'd be grateful if Ms. Durr could be excused. She's very happy to stay if the committee wishes her to, but otherwise she could get on with her other important work.
I'm happy for her to leave. I don't think we're not going to revisit the Newix matter again. But she's welcome to stay if she enjoys our company.
Yeah.
But it's purely voluntary.
I'll leave that to her to make that call. Thank you, Chair, for that indulgence.
Okay. Yeah, I'll come to that. Yeah, no, we'll come to that a bit later, yeah. So, look, what I'd like to do now is just obviously stay online, but if the broadcasting could cease, we'll have a break. If we can just... Okay, so thank you, ASIC. We'll make a start now. I'll just put my phone back onto silent. And as foreshadowed prior to the break, Senator Pratt will have the floor. Senator Bragg's joined us, and he might have he will have a few questions, but on some updates on a range of topics a bit later. So, Senator Pratt, over to you.
Thank you very much, Chair, and thank you to ASIC for being here today. I want to thank ASIC for its engagement in the Sterling Economics References inquiry, and thank the Chair for making reference to that today. Can I commence by asking, clearly in your statement you're aware of the recommendations that the committee made and that you're considering the recommendation to investigate and commence legal proceedings, if appropriate, against AFSL holders that are alleged to have breached the Corporations Act. Can you tell us initially how you might think about addressing that recommendation?
Well, we're still, thanks for the question, Senator. We're still getting legal advice on exactly what is open to us. We're at the early stages of assessing that. It's fair to say that the prospect of ASIC being able to take action along the lines the recommendation is hoping for are very limited. There are technical reasons for that under the legislation. I think my General Counsel there, Chris Savunda, whether he's able to elaborate a bit further. We are considering the options there, but in fairness to the committee and to you, I don't think there'll be a lot of action we can take in connection with that recommendation, but I'll ask Mr. Savunda to elaborate. Our analysis is not complete.
Thanks, Chair Longo, and thank you, Senator, for the question. For the Hansard, it's Chris Savunda, ASIC's General Counsel. Senator, we're obviously giving careful consideration to that recommendation, and it may well be necessary for us, if appropriate, to engage with the committee to better understand the recommendation. The recommendation refers to potential breaches of Section 917B of the Corporations Act. And at least as to our reading of that section, it does not give rise to a conduct obligation. What it is in effect is a deeming provision. So we don't fully understand, although we're carefully considering it, what is meant by breaching Section 917B.
Okay, I can tell you by way of background, that was essentially taken from the judge who said while, in the D.H. Flinders case, who said while AFCA didn't have jurisdiction, it didn't rule out whether there were other breaches under the Corporations Act that could be pursued outside of AFCA's jurisdiction. And that's essentially, I think, from that particular judgment at the time. Is that something you're aware of, that the judge at the time drew attention to those matters?
We are aware, Senator, and that is how we are reading the recommendation more broadly, which is there any action available under the Corporations Act or more generally in relation to licensees' unwillingness or inability to consent to AFCA's jurisdiction. So that's certainly the approach we're taking to that recommendation. I think our initial or preliminary view is it's certainly not straightforward, as in there doesn't seem to be any obvious route to taking action, particularly in light of that case.
It wasn't so much whether it was both, the extent to which those parties can be brought to participate in AFCA's jurisdiction, but also whether outside of AFCA's jurisdiction, that ASIC, as the agency responsible for oversight of the Corporations Act, could identify other breaches that affected consumers that could result in prosecutions or civil liability for the AFSL holder separate to ASIC's jurisdiction, so that it, do those consumers have a more general case against the company, aside from AFCA's lack of jurisdiction?
And certainly, Senator, we will definitely consider that and obtain legal advice on the recommendation, certainly to explore it. But I think as we submitted to the inquiry, even if compensatory claims are available, we've been unable to identify commercially viable claims. And the key aspect of that commercially viable means that there is actually someone that would be available to pay compensation in response to a successful compensatory claim. But as Chair Longo says, we are giving careful and serious thought to the recommendation and will respond in due course.
Okay. I wanted to ask in terms of the opening statement in relation to the market increase in some false and misleading advertising. Where are you seeing that and what does it look like?
You're directing that to the chair?
Yes,
Yes.
I believe so. Yes, thank you, Mr. Lawrence. Yeah, that was not so much a legal question.
Let me just go back to my opening statement and see exactly what I said. Sorry, Senator, just which part of the opening statement?
Take him to the page and the paragraph.
Sorry.
Yeah, no, I'll do that. I just need to find it myself. 4, 5.
I must confess I didn't pick up on it in the statement myself. So
Sorry, I might have
I'm not sure.
jumped somewhat.
I don't think it was in there.
ahead.
Chair, that's fine, Senator. Senator
Anyway,
Pratt.
you can take the.
You just
I think
reclaim-
I got to that because I'd looked up something in your opening statement, and it
Right.
in effect took me to the part of ASIC's website and your
Right.
announcements where you have said you've seen this increase.
Right. I'm not sure. Let me have a go at that. Clearly, we're always concerned about misleading and deceptive conduct in connection with scams, for example.
I think I took it from
and
your
just
corporate
generally.
plan, I'm sorry, not from your
Right.
opening statement,
Right.
which has
The,
drawn attention to the current risks in light of COVID and the changing market, to the particular
Yes.
vulnerabilities
Yes.
of consumers in
Yeah.
relation to false and
No, I think
misleading
it's
products.
I understand. Thanks for that clarification. That's very
No, look,
helpful.
it's I was misleading, false and misleading.
That's
you,
right.
Drawing you to the wrong
No, that's fine. I just wanted
statement.
to just need to understand the framing. I think this whole area, in terms of our consumer protection mandate, is a fundamental part of ASIC's concern that the consumers are not misled or deceived. The way in which they can be misled or deceived is numerous. And in recent court proceedings, in connection with what the banks might be up to, or through scams, or within superannuation, there's a whole range of areas where ASIC is concerned to ensure consumers are not misled or deceived. I might, with that introduction, ask maybe the Deputy Chair Court or Chester if they wanted to elaborate a bit more on our work in that area. And the question's a very broad one, so perhaps if we handle it that way, it'll be more helpful. So I don't know, Senator Deputy Chair Chester, you want to go first, and then I'll ask the Deputy Chair.
Yes, thank you, Chair Longo, and thank you, Senator, for the question. For the purposes of the Hansard, Karen Chester, Deputy Chair ASIC. So, Senator, it's a good question, and it's a very broad church across all of ASIC's remit in terms of what products and services in the financial system we've been focusing on. I think there's two immediate ones that I would draw to the committee's attention. The first one is a matter that Chair Longo referred to in his opening statement with respect to the proceedings we have against IAL. And this is a case where entities are failing to deliver on their promises due to poor systems. And in this case, it was the matter of a promise that was in effect misleading, that these individuals would get discounts or loyalty taxes is another issue with respect to insurance products. And so that's one area where we've been pursuing enforcement action, surveillance action and transparency. We've put the insurers on notice, all of them, in addition to the enforcement action we've taken there, that we want them to review their systems and review that they are delivering on those promises and those promises are not misleading. That's one stream. The other stream of work, and it's one that we've discussed before the committee before, is with respect to the, in the funds management space. That was with respect to whether or not fund managers were being true to label when they were portraying the risk and return profile of the investments that they were offering, particularly to some of the unsophisticated wholesale investors that they were targeting. And the related enforcement matters there, which will give the committee a sense of what we're dealing with, are with respect to Mayfair, which the chair also referred to in his opening statement, but also a matter with respect to La Trobe. And here it was misleading and deceptive conduct with respect to whether or not the risk and return profile of those investments were, as portrayed, were true to label. People were expecting also that the investments were on call, and so they would be able to redeem. And that did not align with the underlying liquidity profile of the assets.
Okay, so that sounds, can I, in that context, and we discussed this in the case of Sterling, where you've got what's underlyingly misleading, but then you combine that with the particular targeting of a cohort of consumers, and it kind of creates the picture that this is almost, it's not that they've just made an error, it's that they are being deliberately misleading in targeting particular consumers who will be vulnerable to the particular pitch that's taking place there. And I really want to understand how ASIC is now putting that together, because I guess what I really learnt from Sterling and from the subsequent law reform, where you've now got to put the marketing and the type of consumer together with the fundamentals of the product, I really want to understand what's changing in that regard and what powers you might need to be able to effectively uphold that obligation.
So there's probably two aspects to responding to that very good question, Senator. The first is how we use technology ourselves and data ourselves today to identify where that may be occurring. And a good example there is the Mayfair case, where it was actually data analysis that was undertaken as part of our surveillance of the funds management industry that identified that the way that Mayfair was targeting a very vulnerable cohort, unsophisticated wholesale investors, by using social media and through Facebook and the like, cash-like returns. So people that were looking for cash yield and cash-like returns were contacted by Mayfair Marketing to suggest that this was a product for them. And that's why the Mayfair decision is such an important one, because Justice Beach found that you cannot use social media or platforms to target individuals in a misleading and deceptive way. So that's from some jurisprudence. Now we've got a greater power there, which is terrific, and it's something that we're looking to do. Indeed, we were discussing this in Commission Enforcement Committee meeting yesterday. The other stream that's very, very important, and this is something we need to thank the Parliament for, is that we now have the design and distribution obligations. And that for us is the real step change here. And it would have also helped us if we could do some analysis across those design and distribution obligations, where a target market determination has to be made to say that this product is of value and is of benefit to this cohort of consumers. And so two things happen there. Firstly, we now have a line of sight, as do the journalists, as do Parliament, as do consumer groups, to look at those target market determinations when they have a concern about a product and look if it's correct or not. And this is a really critical point, Senator, that if there's a breach, so if a target market determination is breached, for want of a better description, it's called significant dealing. So where the product gets to the wrong consumers, or the product is no longer suitable for those consumers, they have to breach report that to ASIC. So it allows us to be a little bit more proactive much earlier on to identify where products might be getting to the wrong consumer cohorts, as opposed to it being when an entity goes into financial difficulties, administration, liquidation, and then we're dealing with issues of compensation as opposed to issues of getting those consumers out of those poor products quickly. The only other thing I would mention is the other great thing about the design and distribution obligations, which does give us some a bit more bandwidth here, is we have step-in powers.
What does that mean?
So that means that if we feel that there is a product that is where the target market determination is deemed to be completely distributed in that
Might just pause for a second.
or direct, possibly.
Yeah, Miss Chester, we lost you for about a minute. Now we've lost you altogether. We could see you, but you were frozen in time. So if you could just rewind 1 minute.
Okay. Can you hear me now, Chair?
Yes.
Yeah.
We didn't hear your answer in relation to step-in powers, essentially.
Okay. So the step-in powers, and this is set out in our regulatory guidance on the design and distribution obligations, mean that if we feel that a target market determination is entirely inappropriate, we have some step-in rights there to ask that it either be addressed or the product not be distributed until that's been resolved. We're in very early days of working out how we would use this power, because the design and distribution obligations have only been in play for approaching 5 months now, Senator, but we've made it very clear in the guidance what we would be looking to do here. It would also be, for example, if we did get reports from the entity that there had been significant dealings, i.e. things had gone astray with the design or where the product was being distributed to the wrong consumers, we can then go in and have a look quickly and see if we need to exercise those step-in powers. But
Okay, can I ask what you're doing in that regard to make, I guess, stakeholder and representative groups of some of those target groups that might be targeted in investments aware of these powers, so that, because what happened in Sterling is there was a complete void really of public interest groups or local community groups or anyone really having any awareness of, talking to consumers about what they were investing in and whether it was in their interest or not. But if you've got organisations like Choice or Council of the Ageing having dialogue about these products, then you'll start to get better reporting and transparency that's feeding through to you in relation to targeted products.
That's exactly right, Senator. Indeed, ASIC's consumer consultative panel that we have, and we've had established for many years now, it's probably one of our most successful stakeholder groups in terms of that live exchange of information, their concerns and what we can do about it. We've discussed at length with them the design and distribution obligations. Indeed, the most recent meeting that we had, we talked about them helping us to identify products and services that targeting going to retail consumers where, sorry, just to go back a step, Senator, it's important to understand the design and distribution obligations only apply to financial products and services that go to retail consumers. So I'll park that for a moment. But importantly, those groups are still looking at any vulnerable consumers, whether or not they're regarded to be retail or wholesale, as was the case even in Mayfair. So we have discussed with them at length our guidance and our approach and what we're now doing from a surveillance perspective with regard to the design and distribution obligations. We even asked them at the most recent meeting some of the areas that they were concerned about for them to identify the top ones and where they had some concerns about some of the target market determinations that they've seen, and they're coming back to us live on that. So that will inform our surveillance going forward, Senator, where we target our resources.
Okay, that sounds great. May we get a list of the organisations or individuals on that group where we were just discussing earlier as a committee our need to engage with some of your stakeholders in our role as an oversight committee so we can hear from them what they're also telling you. So it would be good to see ASIC's various stakeholder matrices, if that's possible. I have a particular interest in that consumer cohort, but others will have interest in some of the other areas as well.
We'd be happy to share with you, Senator, the membership profile of all of our consultative groups. There's about 6 of them all together. On the consumer group that you're discussing at the moment, from recall, there's about 18 organisations represented. So the Choice, Financial Counsellors Australia, Legal Aid, COTA, but we will share that with you. Take that on notice, Senator.
Thank you, that's terrific. PE Capital, there seems to be I'm just looking at recent media on that, and it seemed, notwithstanding the fact that it had some some products that it was selling without a licence at all, it seemed to have some similarities to Sterling in relation to it being a managed investment scheme. What's going on in the managed investment scheme space, particularly when it comes in the context with real property rights or a link to some kind of tenancy, for example?
Senator Sarah Court speaking. I can answer if you would like more details on the PE Capital case per se. I might hand to a colleague if you want some more information about what we're doing in managed investment schemes. But I think one important piece of information on PE Capital, because as you quite rightly say, it does relate to investments in various property interests, but the difference between it and the Sterling set of facts is that PE Capital all related to commercial developments, not retail tenancies, so it was a quite different set of circumstances, if you like, from that group was in the business of developing vacant land on the outskirts of Melbourne into various sort of business opportunities, so converting commercial land from one commercial enterprise into another. So I can go into that case some more if you'd like to know. That's been just in court, as you may know, this week, and orders have been made for that group to be wound up. So liquidators are now doing their work and working out monies there to return to investors. If you'd like more information about the work we're doing on the managed investment schemes more broadly, I might hand to a colleague who is better informed.
Yeah, I would. Thank you. I would like some information on managed investment schemes more broadly as well.
I'm not sure who I can call upon for that subject. I know Rhys Boland's with us. Say more broadly.
Well, would it be more productive to
Park it for another day?
Yeah, and to perhaps just to broadly take it on on notice and provide some briefing material to the committee.
Yeah.
I think that might be easier. Okay.
Can I-
Thank
yeah.
you, Chair.
I guess in that context, I wanted to also ask, I'm happy for this also to be followed up later, but managed investment schemes, it appears, and I don't, in terms of how people make their investments, it appears more likely that they're going to put their financial investments in one basket rather than have a diversified set of investments, and that along with the other inherent risks, I guess I wanted to ask, when you look at something like the Money Smart website and the decisions and the way it tries to guide consumers through their financial decision making, how do managed investment schemes fit in at all as being a reliable product when generally when you invest in a managed investment scheme as a retail investor, you'll be asked to put quite a lot of money on the table to get into it, and it's likely to be a very large proportion of your private investment capital.
Yeah, I think, Senator, just a couple of points. I'm not sure that I agree with a couple of the premises in your question.
That's why I'm asking.
Okay. So with the managed investment scheme, it's entirely up to the person how much of their money they want to put into it. And so it's an entirely private, personal decision whether a consumer or an investor wants to put money into a managed investment scheme. I mean, by definition, when you put money into a managed investment scheme, you are an investor. That's what you're doing. You're investing.
But I guess there are different types of managed investment schemes.
Yeah, that's right. I'm coming to that.
Yeah.
And there are thousands of them around the country. About 5% of Australians' wealth is tied up in managed investment schemes. The balance is tied up in superannuation and various other things. So we can provide a sort of an overview of how managed investment schemes work in Australia in terms of the amount of money that gets put into them. But I think the key point just for this morning is that there's, as a general matter, schemes don't require you to put all your money into them. It matters entirely for the investor how much of their wealth they want to put in, if any. It's entirely discretionary. I think the issue coming out of Sterling was that people didn't get advice and they didn't fully appreciate what they were doing.
Well, they were required to put all their money in.
Senator Pratt.
They were required to put all their money in.
Pause, okay.
Senator,
hang on, everyone pause. I've made clear at the last hearing. I want questions to be answered. The answers are of interest to everybody, and I don't want to have this sort of rapid interchange where people are cut off, okay? That's
my apologies, Chair.
No, you don't have to apologise. It doesn't matter. We're just not doing it, okay? So, Mr Longo, you were speaking, and I heard every second word you said. So if you could go back, that'd be good, and then we'll go to the next question when he's finished.
Thank you, Senator Pratt and Chair. I think all I was trying to say was that even in the Sterling situation, there was not a requirement that an investor, tenant investor, consumer, by whatever name called, had to put all their money into the scheme. What happened in Sterling was that by the very nature of the product and by the very nature of the people who put their money in, that's what happened. In order for those individuals or couples to take advantage of what they were offered, their particular circumstances required them to, in effect, put all of their savings in, which was part of the tragedy of it. But in principle, you could have invested in Sterling without putting all your money into it. You just invested as much as you wanted to put in. So I think we will put together a little paper that tries to summarise some of these principles and some of the statistics, how much of Australians' wealth go into MIS, into managed investments. But I might just pause there.
May I, in that context, ask you if you can advise the committee on, so clearly if someone buys a property in their own name, they've made their own individual investment, or they might make investments through a managed investment scheme where they've got some other benefit or right that's purportedly attached to it. So it could be, as in this case, a tenancy, or in other cases, 3 months holiday accommodation. I'm interested in that nexus of where people, through a managed investment scheme, buy into in effect, a large proportion of a business so that they've got some other benefit attached to it, and how that then pushes them towards a lack of diversity in their financial investment.
Senator, we'll try to be helpful on both points, but I think I gave evidence about this during the Sterling inquiry, and ASIC made submissions. The managed investment schemes are an incredible range of investment options for Australians. ASIC does not look into the viability or commerciality or merits of these schemes. Once they meet the legal requirements of the Corporations Act, we register them. And I really don't want to repeat the evidence I gave.
I guess I'm
in
trying to
Sterling.
work, I understand your current obligations. I'm trying to work
We're
out.
not going to do that. We're not going to do that. We're not going to look at
I understand
5,000
those obligations. I want to know, how do we as a parliament find out if there are real problems here and you need more money or more powers to have obligations here? There may not be a problem, or there may be a problem where there is a very real risk of this type of product potentially breaching design and distribution obligations because of its very nature.
Yeah. Well, all I can do is repeat the evidence we gave at the Sterling inquiry and our written submissions. Parliament, we have a system in Australia where it's easy for people to invest in managed investment schemes. As a well understood system.
I don't need
so
you to
the
repeat
Parliament,
it. I guess I'm trying to work out.
Sorry, I thought I might need it to.
What role will design and distribution obligations have, do you think, in the case of managed investment schemes?
Well, Deputy Chair Chester,
do you expect particular cohorts or particular types of investments to be more problematic when you look at those obligations?
The range of investments available to consumers and investors is very broad. With the DDO regime is very flexible and is designed to give us a power to intervene in certain circumstances. The fundamental principle is Australians have the right to invest in registered managed investment schemes. And there are many of them, and there's there's a regime around disclosure requirements and how they're regulated. Now, in terms of consumer protection, investor protection, there's a whole range of questions are raised there. And again, these were ventilated during Sterling. One is when you invest in a managed investment scheme, should a consumer or investor be given the benefit of some sort of warning system, some sort of health sort of risk check, this is high risk, medium risk, or low risk, the sort of evidence I think former Chair Deloisio gave. So I think that's a legitimate question. What do you do with that? Secondly, we should be encouraging, as ASIC does, people to get proper advice from licensed financial advisors before they enter into investments of this nature, particularly in circumstances where, as you've noted, practical effect of making the investment is to put all their eggs in one basket. That's never a wise thing to do, and I think people need to be alive to that. With DDO, Deputy Chair Chester said, we're in the early stages of working through how we're going to use those powers. I would add to what Deputy Chair Chester said is sort of a note of caution that these powers are to be tested, and we will be looking for opportunities to test them, so to make sure we do use them. I think otherwise, what we said during the Sterling inquiry remains the case, but I'll try to amplify that in written after this hearing.
Thank you, Chair.
Thank you very much. Thank you, Senator Pratt. Thank you, Chair Longo. We're going to, just so people know where we're going, I know there's a couple of individual follow-up questions. What I'm planning to do is to go to Senator Bragg. The Deputy Chair and I are essentially ceding a lot of our time so questions can be asked and give people a go. And I know Senator Pratt's got a whole range of commitments, as does Senator Bragg. So we'll go to Senator Bragg now. Mr Hill will be back here at 12. He's just attending to something and he'll then have the floor. And what I would aim to do, everybody, is just to mop everything up with individual questions prior to the lunch break at 12:30, so that when we resume at 1:15, we're not revisiting any of the issues. We're moving straight to governance, and that's for the benefit of your team too, Mr Longo. Okay, Senator Bragg.
Chair, sorry, Chair. I had two follow-up questions.
No, I know you did, and we'll do them later.
Okay, no worries. I just want to make sure you're aware.
Yep.
Thank you.
I'm well aware. I get your apps. It's okay. Senator Bragg.
Thank you, Chair. Thank you very much for giving me some time. I'd like to talk to you about insider trading, as we've been referring to it as, and I just wanted to thank the Commission for providing a really extensive number of answers to the questions, and I apologise for all the questions that have been asked, but I thought it was important to try and get to the bottom of this. I mean, the idea that there would be insider trading in the compulsory super system, I think, would be a shock to many Australians. And I think that's because this is a compulsory scheme established by the Parliament to provide retirement benefits to Australians. And so I think these matters that you have done some good work on are of great interest to the Australian people. Now, I just wanted to establish again, just to the avoidance of doubt, the law in this space is not actually a conventional insider trading provision, is it? What is the status of the law in the situation that a trustee or an executive of a super fund engages in what we would understand to be insider trading in effect?
I'll have a go at that, then I might ask General Counsel Chris Savandra or Commissioner Press to elaborate. A couple of points. It's almost regrettable that we're using the phrase insider trading, because that's not what this actually is. So the first point is, I would say I don't think it's a helpful verbal formulation to talk about insider trading happening in superannuation funds. I would suggest to the committee that we don't use that formulation. What's really going on here is a concern that ASIC had and that we've been working on. We see it more as a governance issue of managing conflicts around certain individuals having access to information, and then those conflicts not being properly managed when they switch investments, within their fund. And there's a whole range of considerations go into whether, when that switching occurs, whether it's something that's objectionable or whether it isn't. And Senator, Mr. Braff, thank you for. We have put a lot of work into those quants and tried to be quite expansive in explaining the work that ASIC is doing there. But I think it's important to, this is not insider trading, it's a management of conflicts question. And what we're doing with each of the superannuation funds is pressing them for their policies and practices to ensure that the appearance of taking advantage of information or timing of revaluation of assets doesn't appear to be something that's inappropriate or unacceptable. Okay. So our inquiries and surveillance are continuing. Now, I don't know whether Danielle or Chris want to elaborate on that, but I think that initial sort of framing, I think it would be helpful. Danielle or Chris?
For the Hansard, Danielle Press, Commissioner of ASIC. Joe, I don't have anything more to elaborate from what you've said on that answer.
Okay. Well, okay. No, thank you. And the answers you have given are very good and very clear. So thank you very much. But I do just want to try and nail down this concept, because I think I think it is important that if the Parliament in the future is going to give consideration to how to deal with the legal design, we need to understand exactly what is currently in scope. And I understand what you're saying, Chair Longo, about it not being a helpful term. I guess it's been called insider trading because the allegation in broad terms is that trustees or executives of super funds have used inside knowledge of valuations of unlisted assets to gain personal advantage. That is the allegation, that they have used that inside knowledge they have about the lag in the valuation to trade in advance of that valuation being known more broadly, including to the members of the super fund that they owe a fiduciary obligation to. So what would you suggest we call that then, if it's not insider trading? Is there another phrase you use at ASIC?
Well, as I've tried to say before, as far as ASIC's concerned and in corporate law is concerned, insider trading has a particular understanding, and it involves trading in financial products or securities while in possession of information that hasn't been made available to the market. And that's generally in connection with publicly traded securities. And ASIC runs a number of insider trading cases every year, generally successfully. It's a serious offence. And at any one time, we have a number of insider trading investigations on foot. So I suppose what I'm trying to say is it's not that kind of insider trading we're talking about. It's not that kind of problem, if I can put it that way. Now, I understand from a broad perspective, the way I would explain it is that this is a director's duties issue. That if you're a senior officer or director of a trustee, then you're allowed to switch, your asset allocations. You're allowed to do things within that fund if you happen to be investing in that fund, in your own fund. But what you need is good governance around that, so that the market, the community, the Parliament can have confidence that the trustees are not abusing their positions. That they're not using information inappropriately or along those lines. So I personally don't find insider trading the right concept, but I understand how people might feel that's a good shorthand concept. Okay. I personally don't find the way to deal with it. Yeah.
Okay. Well, that's understandable. So now, in the questions you provided through the committee at Christmas or by Christmas, ASIC identified 67 individuals that you had investigated. Is that right? Did you investigate 67 people?
I'll ask Commissioner Press to get into the detail of that. It's quite a busy surveillance program we're working through there. So I'll ask Commissioner Press to give some details.
Senator Bragg, that is correct. Before Christmas, we had looked at 67 people. We actually expanded the scope after that one had been finalised, and we added another 60 people to that scope. The avoidance of all doubt, to ensure that we were being erring on the side of caution. The reason those 60 people that we added didn't initially meet the criteria was that they hadn't actually done a switch, but they had made other changes to their investment program, which we thought were worth looking at.
Okay, so Commissioner, you're saying that you now have investigated 127.
That's correct.
Okay, and you broadened the search, or you broadened the investigation because you discovered that more people had undertaken personal activity, or because they were trustees on the same boards, or why was the investigation doubled in size?
So it was really, as I said, out of an abundance of caution, that we wanted to ensure that there wasn't any inappropriate use of information that they held. So the type of things that we broadened the scope to were including a trustee had changed their ongoing investment program. So they might have been in the balance fund today. They had changed all ongoing contributions to cash. We wanted to ensure that that was actually an appropriate thing for them to do and not inappropriately using information that they had gained from the fund,
Okay.
as an example.
Okay. And so am I right in saying that you've now narrowed it down to 4 current executives or trustees?
We just lost your audio, Danielle,
Sort
sorry.
of the pivotal moment.
I think I managed to put myself back on mute. I apologise. Yes, that's correct, Senator Bragg. We have ongoing investigations into 4 individuals.
Okay. And are they trustees or executives?
Or if you can't answer that,
I would need to go and check, to be honest, exactly which bucket they fall into. I don't have that at hand.
you happy if he does that?
Well,
I can probably find
provide
the
it on
next
notice.
little.
Yeah. Can we get it on
On
notice?
notice?
I'll ask to have a look for me.
Yep.
Okay.
We can have it on notice if that's not possible.
Okay. Because I think this takes us to the key point. I mean, these are obviously matters of great public interest. I understand that ASIC needs to go through their investigative processes. But are you effectively seeking a PII claim over this matter? Is that right?
I'm going to ask my General Counsel, Chris Savundra, to answer that one on the questions on notice, Chris, from December.
Okay.
Thanks, Senator. Yes, we've written to the committee secretariat asserting a claim for public interest immunity around the detail. I think we're happy to answer questions at a high level as to what we're doing, but I think from memory, one of your questions was around specific trades, and we're just concerned about the potential impact that might have on our ongoing inquiries.
Okay. So under what grounds are you filing the claim?
Senator, if you can give me a moment, I'll try and pull the letter up, but from memory, it's
Can I just suggest a
concern around.
Can I suggest a course of action? And this is to help everybody. Senator Bragg wasn't here when we had a private chat before about flagging some of the issues we'd come to. What I'm going to suggest is we go straight to Mr Hill now, because ASIC are prepared for that. We'll come back to you, and that'll allow some time for ASIC to work out what they can give us today or what they can't. Is that fair? Okay.
That'd be helpful, Chair. I've now got the letter in front of me.
Yeah, well, we'll still go to Senator. We'll still go to Senator Hill because I'm conscious that
He's demoted me.
Promotion.
Demoted me.
Senator, oh, sorry, that's even actionable. I'm sorry about that.
That's right.
Congratulations.
Julian, it's easier.
Yeah, that's all right. That too. Just a few
We've
quick
got
questions.
6-year terms, Chair. 6-year terms in the Senate.
That's right. That's right. Well, we get elected with 50% plus one. So.
6 years of work in the 3 years.
Okay, Julian.
Just some questions on Section 19. Section 19 is part of the ASIC Act that allows you to compel people to attend interviews. There's a further provision also in the Act, Section 22, that allows ASIC to direct an interviewee not to discuss the questions asked or the answers given with anyone other than their lawyer. Is that a fair summation of those two provisions?
That sounds fine for now.
Okay, good. Could you advise how many Section 19 interviews you've conducted each year for the last few years? And is this a regular tool in ASIC's enforcement toolkit?
Yeah, I'll hand over to Deputy Chair Court. I don't know whether she has statistics at her fingertips, but Section 19 is certainly a very significant part of ASIC's investigation toolkit.
Thanks, Chair and Mr Hill. I can certainly confirm it is a very, it's a tool that is used very regularly, but Warren Day, who's our Chief Operating Officer, has the precise statistics to hand. I will hand it to him.
Thanks for the question, Mr Hill. It's Warren Day, Chief Operating Officer at ASIC for the sake of Hansard. In terms of the number of Section 19 notices that have been issued each year, those notices are approximately, for each of the last 3 years, vary between about 22 to 25% of all notices issued. I don't have the exact breakdown, but I can tell you that in the 1920 year, we issued just over 5,000 notices in total. And in the 2021 year, we issued approximately the same number of notices. So you can see that it's probably about just under 1,000 notices a year might be for attending Section 19 examinations.
Okay, all right. So that in your views remain reasonably steady. If you could just take that on notice and give us the breakdown in a
Certainly.
Answer, that'd be great.
Certainly.
And so what proportion, again, you might need to take some of this on notice, in relation to those Section 19 interviews, what proportion of those have wound up in a prosecution, what proportion have wound up in no action, and what proportion are still under investigation?
I can certainly have confidence in saying I will have to take that on notice.
Yeah, I thought so. Fair enough. Is there any colour and movement in that, Chair, from any of the commissioners?
Well, we will have to take that on notice. That kind of data will need to put some work into extracting them from our systems. But there was an aspect of the question which I wouldn't mind clarifying now.
Thanks.
With the help of the chair. When we conduct an investigation, and Deputy Chair Court will be more articulate about this than me, it's an investigation. So very often we will conduct a range of Section 19s of a range of people. And by the way, we might send a notice to an individual more than once. So in that statistic Warren Day was talking about, the same person might get 2 or 3 notices. So that doesn't mean we examine 1,000 people. It might mean we examine 500 people. But the point I was getting at was that during the course of an investigation, it won't surprise you to know that we keep an open mind. So very often we don't know whether we're going to end up referring a matter to the DPP or civil proceedings or a banning order. So the Section 9, that process just doesn't work that way. There are times when we might start an investigation with some confidence that we have a particular outcome in mind, in the sense of this will never be a criminal matter, but it might be a civil matter. But generally speaking, during the course of an investigation, depending on where the evidence goes, we won't know till later on whether it's criminal, civil, otherwise. So can I suggest we'll come up with some data for you that I think meets the spirit of your questions, if I can put it that way.
No.
But I just wanted to stress that point. Deputy Chair Court, I don't know whether you wanted to add anything to that or qualify any of it.
No, I don't, but I can see Mr Day speaking, but you're on mute, Mr Day.
Thank you. Mr Hill, the other thing I would add to what Chair Longo said was there's a large number of people who effectively want to get a Section 19 notice. They want to be compelled to give information for a whole range of reasons because it relates to their employer and so on. So I don't think it can be equated that just because a Section 19 notice has been issued to someone that they're either a person of interest or in fact may at any point ultimately become a person who's prosecuted.
Yeah, absolutely. And I'm aware of that point, but I think it is important to have it on the record in any discussion around this. That makes perfect sense. Do you have any sense, or could you take it on notice, how many people have been directed not to discuss questioning in a Section 19 interview, effectively invoking Section 22? And maybe that's one you could take on notice. Out of the proportion of... sorry, go on.
Well, I was going to say, I don't know that we'll actually be able to answer that question because I don't know that we keep a record of that, because in a number of investigations, that would nearly be identified, if you like, or that direction given at the conclusion of that Section 19 examination. But whether or not it has or it hasn't, I don't know that we keep a formal statistic about that. But I'm happy to go away and say we will see whether we can give you that information, but I don't know whether or not we can.
Yeah, okay. That's probably the heart of my interest at the moment, and it's maybe I'm misunderstanding it, but that's a I wouldn't say extreme, but that's for the individual concerned, a fairly draconian kind of restriction put on them, which integrity bodies have for good reasons. It would surprise me if you didn't have some system. Sorry, just let me finish. It would surprise me if you didn't have some system to record the use of Section 22 powers and you couldn't quantify some statistics around that. I mean, it's not just kind of like a TATS ticket you give them on the way out.
I'm a little bit surprised why you're surprised in certain respects, Mr. Hill, because obviously in an investigation, you can't necessarily examine everybody simultaneously at the same time. So what you don't want, obviously, for practical purposes, for investigative purposes, as I'm sure you'll appreciate, is effectively people telling other people what they were asked. So I don't think it's actually that unusual in that respect, and I don't think, in fact, as you say, it's
sorry, Mr. Day. I think we might have just misunderstood each other. I'm not at all surprised that you use them. I would be surprised if you don't record statistics around their use and where they're applied and where they're not.
Yeah, I think the reason why I'm saying what I'm saying is because the practical reasons that I outlined, that you would see that it would nearly be in most cases that we might need to do so. But again, I'm not sure of whether or not we actually count that, if you like, as a number. So I'm happy to take that away and look at that and come back to you if that's the case.
And so again, for the last 3 years, how many people have received breaches in relation to violating a Section 22 direction?
I'd have to take that on notice, Mr. Hill.
Are you aware of any?
I'm not that close to enforcement processes specifically on day-to-day basis at the moment, Mr. Hill. So I'd have to take that on notice.
No problem. If a Section 19 interview ultimately in a matter reveals no wrongdoing and an investigation is closed with no action, do you then waive the secrecy provisions under Section 22? Is that gag removed? And if not, why not?
I'd have to either see whether or not Mr. Savundra can assist me in that, but I assume at the conclusion of the investigation that's released.
Can I?
Mr. Hill, if I could take that on notice and just check the answer I'm about to give you, but when we make such a direction, it's usually time limited. So we put a date on which that direction not to talk to others is to remain in place. And obviously, it's an exercise of power. So the person making that direction needs to ensure that the direction is only in place for what is considered to be a reasonable period of time. So it is quite common for us to extend that date if the investigation's ongoing. Otherwise, it will ordinarily lapse on the date which is specified as part of the direction.
Is that date?
Rather than
is there a standard?
Rather than the end of the investigation.
Sure. Is there a standard date or default kind of time frame for use of Section 22 notice? I know some of the corruption or integrity commissions, it's quite a long time frame. It can be 5-7 years. In other instances, it might be much shorter. So is it like 3 months, 6 months, 5 years, 10 years?
I'd have to check that, Mr. Hill. If I could take that on notice, please.
Okay. And look, the final question there, obviously being able to conduct interviews and direct interviewees not to discuss the answers is a powerful and an important tool, necessary tool of a regulator. I understand that. What assurances can you give the committee that the secrecy provisions are not being used to stifle criticism of ASIC and or the government, and what controls are in place, policy or operational, to prevent the misuse of these powers?
So, Mr. Hill, I'm happy to respond to that initially and see if others want to add. The direction is pertaining to the content of the examination itself, and I take your point that sometimes it might be necessary to refer to the content. So the content is the questions asked or the answers given. That doesn't stop someone being, without disclosing that content, being critical of ASIC. We obviously have, comprehensive procedures around complaints about ASIC. So if you wish to complain about ASIC, you make a complaint to our professional conduct unit. We're overseen as a law enforcement agency by ACLEI, so that, you can complain to ACLEI, you can complain to the Ombudsman. So I wouldn't expect it to be used as a device to limit criticism about ASIC. People are free to speak about their interactions with ASIC without disclosing the content of the examination.
Yeah, I mean, it's an unproductive line to get down that line for me. Look, I appreciate that. If you can take on notice the questions we've put, I have no expectation whatsoever that you'd be able to answer the statistics here. The reason, if you like, that I didn't perhaps telegraph this, I was somewhat curious to see the extent to which senior officers at ASIC have any line of sight to the use of these powers or can point me towards the policies and the controls. Now, complaints to ACLEI and your complaints process is one thing, but I'm not getting a strong sense that this is a significant issue that reaches your lofty heights often, or if at all, in terms of how these powers are actually being used and indeed what the policies around their use are and where the balance is being struck. So
I think, thanks, that assists, Mr. Hill. So I think in terms of formulating answers to your questions on notice, we'll take as part of that a description and an outline of what the policies are, so that you can understand that. And then if you've got further questions, once you've got that, we're happy to assist further.
Yeah, that's fine. I mean, there's a few specifics sitting behind that, but this area of interest, but I don't want to or need to go into that at this time. We'll see what the questions come back to. Final question, Chair. I noticed yesterday.
Chair's leave.
Sorry.
Sorry. With the chair's leave, can I just add?
Sure.
No, you don't need to leave. Just jump in at any time. You're the chairman.
Well, that's very generous, Chair. The question of Section 19's the ASIC, and before ASIC, ASC has had a Section 19 power for over 30 years.
Yep.
And it's a very well understood and utilised power that we have. And secondly, there are actually a number of court decisions which we haven't had any for a while now, but when the power first was conferred on us, there were a range of court cases sort of exploring aspects of the use of that power and what a Section 19 notice should look like and what it should say. And indeed, the issue you've been pressing has been the subject of court cases around whether the same lawyer can act for a number of Section 19 examinees. So there's a lot of understanding, I think, and thought given at ASIC to this power, because it is very intrusive. It's a key part of our investigation toolkit, and we will take very seriously the questions you've raised. Just one final point, and I think Chris Savundra, this question of what you can talk about after you've been examined has been there from the beginning. And the general principle, as I've always tried to understand it, is that you can talk about what you think or feel about ASIC anytime you like. But what you can't do, if this direction is in effect, is reveal a particular question you've been asked under oath at a Section 19 examination, and your response to that question. That's what's protected. Because underlying that direction is a protection of the integrity of the investigation process. That's what this is all about. And as Chris Savundra was saying, we're looking to have an investigation process that's integrity, that's confidential, that people's reputations are preserved while we're doing our job. And so we don't let people know that the public know who we're examining under Section 19, a confidential process. But I take on board your questions because they're important questions, and we'll do our best to answer them fully, Mr. Hill.
Thanks. Yes.
You had one last question.
I did. I just, despite the fact the chair briefly demoted me to the Senate before, we do pay attention to what they do over there and mucking up our work. And there was an interesting episode yesterday.
It was the greatest insult I can give them. So
thank you. Yeah, no, that's okay. Apology accepted. It was an interesting incident yesterday where the proxy advice sector regulations were disallowed by the Senate, and The Fin Review article I'd refer anyone to if they haven't read. It says Josh Frydenberg sustains full-body gravel rash. Talks about this vindictive, reprehensible regime being ambushed by the Senate. But it also refers to the fact that the government had established an entire new capability inside ASIC. A whole new capability you got to police these 4 companies that employ 30 people and generate $5 million of revenue. And that this capability had 72 hours as the cop on the beat. So I was just wondering if you could update us and perhaps report on what did you achieve in the 72 hours with this new capability?
Now, Chair, I think that's a very mischievous question, Mr Hill.
There's no doubt about that.
The Senator designated.
Don't compliment him, Chair Longo. Don't compliment him.
Look, the regulation had effect for a while. In accordance with our usual processes and procedures, we applied our resources in order to be able to discharge our duty to administer that regulation, extending the licensing regime. As things turned out, that regulation was disallowed, after a few days, and that's that. There's nothing more to say, really.
So how many? I won't quote the rest of the article. It calls one of my colleagues here intergalactically dim, which I think is a little unkind.
Two things, Mr Hill. You know me well enough. You're not going to use a committee to give an adjournment speech because the House isn't sitting. And I think you've achieved your main objective, which is to get a follow-up column on Monday.
I'm actually curious. So how many staff did you get in this new unit?
I might get Commissioner Armour to give some details, but the short point is we did not do any additional hiring. We used our existing resources to gear up to administer this regulation. As you know, the entities involved are already licensed. And so in terms of resource impact on ASIC, it was minimal.
Did we get any business cards printed? Any business cards printed? New sign on the door?
I think I can reassure the committee that to the extent the staff involved in this matter have business cards, that they didn't change.
Right, okay, so you took it that seriously. Oh, that's good.
Mr Hill,
Look, the resources
no breakup.
we were able to deal with this within our existing.
No breakup tea party.
No, we're getting to the point.
It was a glorious golden era, those 72 hours for corporate
I'm
regulation.
withdrawing the call, and
Thanks,
we're going to
Chair.
go back to. That's good. We're going to go back to.
Chair, just before we leave Mr Hill, could I just respond to a question that Mr Hill asked earlier about whether a change in the ASX CEO would have any implication on the attestations required under the licence conditions? And the answer broadly is no, because the attestations under the licence conditions, both the senior executive attestation and the board attestation, can be given by any person on behalf of those relevant organisations. They're not personal to an individual.
Yep. Thank you for clearing that up. Appreciate it.
Thanks for that and for clearing it up within the hearing.
Do give our best to the staff also as they return
Mr.
to
Hill,
normal programming.
Okay. I'll give you some time later on when the broadcast has ended. Okay.
No.
Now we're going to go to Senator Bragg, and we've given ASIC some time on the issues that were raised, and I've kept an eye on the clock. So if we can go till about 20 past, Senator Bragg. So,
Okay.
And then we'll go to Senator Scarr just before the lunch break. And as I said, then when we come back, it'll just be governance. Okay.
Well, I think I can knock this off, Chair. Thank you. And I thank Mr Hill for that comment. There's no question that I'm not a particularly smart fellow. And I think
said it was unfair to call
and I think that would be the general consensus from most people who know me. So that is very good. So look, I'll try and pick up on the PII claim if you are able to say anything about that now, because I think even if you were able to describe in broad terms what sort of activity you're concerned about, whether it's the sort of trading I described earlier or something else, I think that would be helpful, just so we understand what it is that you're happy to put into the public domain and what it is that you're, in broad terms, wanting to keep private so that you can pursue prosecutions.
Who we got?
Senator, I might hand to Commissioner Press to respond to what we're prepared to say publicly. I'm happy to speak to the basis of ASIC's claim of public interest immunity, but Commissioner Press, did you want to start?
Senator Bragg, I think we can broadly describe that we're looking at as that switching between the portfolio places as we've described before, and as the 4 individuals were in the first 67 cohort. So it's very much around that potential use of knowledge on a switch from or to an unlisted or a portfolio that had unlisted valuations and unlisted assets. And I think, to be honest, that's probably all we can say publicly until we complete the investigation. I can assure you that the 4 that we're looking, I can tell you now that the 4 that we're looking, the 4 individuals we're looking at, 3 of which are trustees and 1 is a director, an executive.
So 3 are trustees, one
That's
one executive.
One executive.
Okay. What do you think is the timetable for getting to prosecution?
I think to say that there's a timetable to prosecution is possibly a little preemptive. We are still investigating whether there is a case for us to pursue. I would hope that this is wound up relatively quickly, but I couldn't put a date on it right now.
Okay.
It will take as long as...
Oh, I understand that, and obviously the chair and the committee will consider the claim in the usual way. Okay, can I also ask you about insider trading and proxy advisors? Does ASIC have any concerns about whether there's any link between proxy advisors and insider trading in Australia? I think it's been raised in some other jurisdictions.
I might ask Commissioner Armour to comment on that. I don't have a particular...
Okay, thanks.
I'm happy to take on notice to check our records, but my recollection is that we don't have complaints that suggest that is an issue here, but I will go and check our records in case my recollection is incorrect.
Okay, thanks. My last question is just in relation to the question I asked you on notice on whether or not, which is question number 050-01, which is the question asking whether or not ASIC was warned about the risks that superannuation funds members faced from trustees or executives engaging in this sort of switching or insider trading behaviour in 2020. So your answer to that question is that there were no warnings during that period, during the period of 2020, from March to June 2020. Is that right?
If that's what we said, that it is right. Commissioner Press, can I ask you to comment on that?
That's correct. That was what the response in the question on notice was.
Okay. Well,
the question on notice was specifically towards Ms. Chester.
yes, that was agreed between the committee and ASIC. So is that right, that there was no correspondence provided during the month of March 2020 to Commissioner Chester warning about insider trading or of this sort of switching behaviour?
Given Ms. Chester is on the line, I might ask her to speak for herself.
Thank you, Commissioner Press. I'm just getting myself off mute. Senator, I can confirm that the normal processes were gone through to search the systems based on that FOI request, and I also have no personal recall of receiving any electronic communication or warning to that effect during that time period.
Okay. Very helpful. Thank you, Chair.
Thank you very much. Just before we go to Senator Scarr, the Deputy Chair has Just one question.
Just one question on a article that appeared in the Australian on February the 3rd earlier this week regarding Canaccord, and which is a major investment bank, and the article claimed that they'd regularly failed to disclose potential conflicts of interest in companies that it promotes to its clients. Have you had any investigations into this? It's been, from what I read in the article, an ongoing issue, and there's been some other articles earlier on. I was just wondering if there's any action that ASIC, if there's anything been referred, have you had any discussions with them?
So perhaps I can help with that question. Kathy Armour here. We are aware of that article. Supervise Canaccord as part of the oversight that we provide to market participants. We have had numerous discussions with them about their approach to managing conflicts, particularly in relation to research, and the situation where research is written over companies in which they may have, they or advisors may have an interest. And as you would have seen from some subsequent articles, the company has indicated they are making some changes to their processes and procedures. We are in conversation with them and will continue to be in conversation with them about the improvements and changes they make.
Okay, thank you. Thanks, Chair.
Thank you so much. So Senator Scarr has indicated he had some follow-up questions on Sterling, I think, didn't you, Senator Scarr?
Yes, I did, Chair.
Okay, so you've got until 12:30, but it's not compulsory to use all the time, obviously.
Okay, all right. I don't know how to take. I'm reflecting on that, but just
We operate differently in the House. That's what we're saying.
In relation to Sterling, I should note that I was the author of the dissenting report on the Economic References Committee, so I guess I'll put that on the record just in terms of context. Chair Longo, in the course of the hearing, ASIC did, I think, reflect very responsibly on whether or not there were things that could have been done differently in terms of its response to the Sterling situation. One of those, and this is referred to in the majority report in terms of testimony given by yourself, was whether or not ASIC could have done more to make it known to participants in the scheme that ASIC had undertaken a stop order process, initiated a stop process, had obtained a stop order, and that participants in the managed investment scheme therefore did have some rights arising from that process. I'm just interested to know, it wasn't touched on in your opening statement, I am interested to know where those reflections are leading to, whether or not there is some sort of process being undertaken with respect to the learnings from the Sterling process in that regard.
Thanks, Senator Scarr. That report, it was first released last Friday afternoon, and the team and myself have been reviewing it and in fact discussing it on several occasions since last Friday. So we are reflecting a lot on the views expressed in that report. In particular, and I think I sort of gave evidence about this during the inquiry as you reminded me. Yeah, I think it is fair to say that we are looking very carefully at changing some of our processes and thinking internally to, frankly, be a lot more robust and about expressing our views publicly in circumstances like Sterling. Now, in the Sterling situation, in fairness to ASIC, we did a media release. But it just wasn't enough. I mean, as I said during evidence, and I think I'd like to think that, and this is something we need to work through with our own, with our staff to change our systems and processes so that it's embedded in the way we do our work. I think we need to be more energetic in those kinds of circumstances. We need to be more open and energetic with the community about our concerns. If a media release without more, we need to do more. I think I've made that clear. While we're talking about this, the other thing that we are doing, and this will take a little bit of time, is to reflect on one of the conclusions reached in the report is this question of the timing of referral to enforcement. You'll recollect that the matter came to our attention. It got some work, so surveillance area, and then it went off to enforcement. And I think it's fair to say that we are reflecting on that happening more quickly, so that the enforcement approach and thinking is brought forward in similar circumstances. Now, how we actually do that in the Sterling situation, I think, in fairness to everybody, there was a bit of both hindsight in that. So the issue for ASIC is that, as I try to explain in evidence, we literally get between 8,000 and 12,000 reports of misconduct a year. And so the challenge for us is to be able to identify emerging issues and then give them the attention they need in a timely manner. And so that does require a review of our systems and processes and the way we assess things, so that we can meet community expectations that we're going to respond more quickly and more decisively to a problem. And I think coming out of Sterling, there was really some disappointment that ASIC didn't move more quickly. And so we're reflecting on that. We're thinking to ourselves, well, on this, if this all happened again, which I regret to say, which investment schemes are failing all the time, how would we respond differently? So maybe at a subsequent hearing, we can talk a little bit more about that. But I can assure the committee we are thinking very carefully about what we can learn about moving more quickly. Now, having said all that, I hate to have to say it again, but we do need to meet certain standards of evidence, be able to get things done. And secondly, and this is a thing, I'd like to take this opportunity to repeat it, that we can't do everything. And so part of our challenge is to make good choices about which matters to take on and which matters we can't take on. And hopefully most of the time we will choose and run the matters that are causing the most harm for consumers or investors, and where we can make the most difference. And that's just another challenge for regulators, right? They can't just be everywhere at once. But we are thinking very carefully about what happened in Sterling and trying to take some lessons from it. So I might just stop there, because I'm quite happy to take any more.
The only other, in my short time available, the only other area I want to touch on, and it was the focus of my dissenting report, was the role of the Western Australian government. And
Yes.
the fact of the matter is, there was a key document called a payment direction deed, which in many cases, 2 cases that went to the Supreme Court, was signed by a Sterling entity, by a landlord and a tenant. And it essentially said, had a non-recourse clause that essentially said, if the income flow from the investment trust wasn't sufficient to cover the rent, then the landlord could take no action against the tenant. The Western Australian Supreme Court found that clause was inconsistent with Western Australian residential tenancies law, sections 27 and 82, I think. Now, it seems to me, under the current mechanism, structure, etc., ASIC is never going to be looking at the details of Western Australian residential tenancies law and how it may impact on a particular residential tenancy arrangement where the payment of rent is dependent upon income generated from a managed investment scheme. I mean, it just seems to me that would never be on your radar, and I query whether or not it should be on your radar at all anyway. It seems to me to fall within four square within the Western Australian view of the Western Australian government. Do you have any thoughts with respect to these issues where the income generated from an investment, that investment flow, cash flow, goes towards paying a rent under a residential tenancy, which is governed by Western Australian law? Because it was a real issue in terms of that case. because the tenants were surprised, horrified to find out the impact of Western Australian law.
Yeah. Senator, it's a great question. Let me try to approach it in a number of ways. We've all had our say. There was 3 days of evidence. The Senate inquiry landed where it did in apportioning responsibility, that's the best way of putting it, between ASIC and Consumer Affairs in Western Australia. I think from my perspective and ASIC's perspective, there might have been a potential for Consumer Affairs in WA to be more active more quickly. But in the end, a group of people really suffered from what went wrong. And so it's a bit unseemly for me here today to say, oh, well, WA Consumer Affairs should have done a lot more. But I think the real issue here is that and we've been discussing this as well within the Commission, and in particular, I've had this conversation now with 2 of our regional commissioners, is that I think there's an opportunity here to refresh and re-examine our regulatory relationships, if I can put it that way, with state regulators in circumstances where, okay, it's not my responsibility or ASIC's responsibility, as you pointed out, to worry about residential leases, but nonetheless, it's one country, we're here to, do the right thing by everybody. So I think one of the things I've learned from the Sterling thing is that we need to have good and continuous working relationships with those regulators, like Consumer Affairs, that have interactions with consumers, the same people we're trying to look after. So I think there's a learning there for everyone. We've got to be engaged with state regulators as much as we can be, so that a Sterling situation doesn't happen again, where one regulator should be saying to the other, look, we've got to be working together on this more quickly. So I feel strongly that we need to look at that again and see. We have another matter, another state where we're working with a state regulator, and that's going reasonably well. But again, there's lessons from that we're learning. So the fact of the matter is, we're in a federation. ASIC has its jurisdiction. Sometimes there's overlap with state regulators, and I think the expectation of the community, they don't care about demarcation disputes. They want the problem dealt with. And so for my part, I want to reassure the committee that ASIC will do what it can to work with state regulators to good effect, and try not to stand too much on dry jurisdictional demarcation disputes, because I think that's not very productive. But anyway, the property area, the only other thing I'd say in closing on this one is that, and this came up earlier as well, that this has been around for a while, this, broadly speaking, property issues are state-based. It's not really an ASIC issue, but as your question shows, there's a bit of a blurring going on where the two are intertwined, and there's sort of work for both to do. And that's a challenge for us, so that we are reflecting on making that work better.
Yeah. Okay. Thank you, Chair.
Thank you very much. No, thank you, everybody. So we'll just end the broadcast here for the lunch break. If we just get the Hansard broadcast to go to ASIC, and our 2 officials from Treasury. Okay, and this section of the hearing this afternoon is focused exclusively on governance issues, and I should say partly the interaction between ASIC and Treasury. So I'll kick off and say to the chair of ASIC, Mr. Longo, as I said earlier, my view of our oversight function obviously is to ask questions, get answers either here or on notice, and that's obviously something that all the oversight committees do, but I think it's also important for oversight committees to have broad discussions that are not interrogations, but really so that members of the committee can just gain a perspective, and indeed, ASIC can know what some of the interests are, and it doesn't mean there won't be questions within it, but I just want members of ASIC and the committee to be able to talk more broadly about a few things. And so the topic of governance, I'll lead in and just ask a broad question, but obviously you can answer broadly and over a period without feeling, the clock's ticking. So you've had capability reviews, you've had other reviews. There's lots of commentary from time to time about the structure of ASIC. So I suppose the question on behalf of all members of the committee is, now that you've been there for several months, your views of the structure, whether you think there should be a different structure, or what you think, probably more pertinently, of some of the suggested structures, such as having a board and the like, with the benefit of having obviously worked in the area for a long time, but having been there as the chair of ASIC. So that is a fairly deliberately broad question, so that we can open the discussion. And so I'll throw to you, Mr. Longo.
Thanks, Chair. I did think about having some prepared remarks, but the remarks I'm about to share are really just in response to your broad question. So in no particular order, a few things. The structure that ASIC operates under at the moment as a commission, we're all statutory appointees, and the powers and functions of the commission of ASIC are, discharged and executed through the commissioners. Now, over the years, just as an aside, I would say that the concept of an accountable authority has been introduced in the last 5 or 10 years. But for the purpose of your question, essentially what we're operating under now has been the case since 1991. And it's been I think, a very stable, effective way of running ASIC. And so we, as an institution, this is how we've been run for over 30 years, and I think it will. The second thing I would say is that, just as a very broad comment, is that we are a law enforcement agency. We have a very broad enforcement and regulation remit, and as your question noted, there have been a number of inquiries, at least 4 or 5 I can think of. My general counsel is much better at remembering them all than me. But you go from the Wallace inquiry, you've got the URIG report, which was if I could just remember what year that came down. The URIG report back in 2003 was a landmark, highly respected study. I'll come back to it in a minute. And then there have been subsequent inquiries as recently with the Royal Commission. And this goes to another aspect of your question, and that is sort of the idea of a board. Now, it is true I've been thinking about these issues for most of my professional life. I've had a lot of interaction with regulators all over the world. The idea of a board is not unique. The Financial Conduct Authority in the UK has a board made up of the good and the great of the City of London, and the CEO of the FCA sits on that. And so we have that to take in mind. But from my perspective, I think the issues, and I think the Royal Commission looked at this and the URIG report looked at this. In order to do what we do, you need to be independent and not have conflicts or have the appearance of conflict. All of the commissioners at ASIC are independent individuals appointed by the Governor-General. We have clear statutory duties and functions and powers. And I think in order to do our job, we are able to discharge those duties because of their independence. Now, it's often said in defence of having a board that, we need a board because we don't want our regulator to lose touch with what's going on in the business world. We want it to be a credible regulator that's not out of touch with business, and we want the regulator to be in some way accountable. And to that, I would say that I think that is a misguided approach. I think when you step back from the way ASIC is organised at the moment and regulated, let me see if I can quickly summarise this point. We have 3 parliamentary committees, including this one, that we appear before regularly. We have the Financial Regulatory Assessment Authority, which has been in place now for a little while there. And for 4 or 5 years now, we've had an industry funding model where we are very transparent with the market about how we spend, the resources of the Commission, because we are industry funded. So there are various mechanisms and approaches where, as a regulator, as an independent regulator, we are accountable. We are accountable to the Parliament. We are accountable to the people we regulate through these various mechanisms. And I think to have a board would not add any real value. In fact, it would create a lot of problems. So I think they're the main points. It's a big subject, and I won't go on and on. But Chair, I'll just accept that question in the spirit in which you asked, and I'll just give you that sort of response, and then we can open it up from there.
No, and that's good. And of course, in asking that, as I said on behalf of the committee, I'm not. We're not advocating one way or the other, but really there has been so much commentary around it, and I think certainly as chair, it's one thing I'd like us to just address in part of our report when we do report, excuse me, to Parliament a little bit down the track. So that's very useful indeed in terms of how you're describing it and your long experience having looked at it, and obviously come to the conclusion that you can't, and I am putting words in your mouth here because we're having a general discussion, so correct me if I'm wrong, but you can't see a system that works better anywhere else, and there's really not a problem you can see that would have been overcome by having such a board. Is that fair?
Yeah, I think that is fair, and I suppose, look, with the thoughtful people who've thought about these issues over the years, I think we can all agree there's no perfect system, there's no perfect model, right? And so I think all I would say about how we are currently organised and structured, I think it works. I think it meets the need for us to have a strong independent regulator, but it's not totally divorced from the needs of the Australian people. And we have that parliamentary oversight. So I think that's, to my mind, that strikes the right balance. But we can unpack that in the discussion we're no doubt about to have.
So I'm going to chair this very differently to the earlier session today. I said I wanted a broad discussion, so I'm not going to go in order. I'm just, if people are ready to jump in, I'm conscious Senator Scarr's on the line. We've got the Deputy Chair and Julian Hill. Who wants to extend this conversation?
Chair, I might, if you're happy, I might ask questions. Chair Longo, I should say I probably agree with you, I think, reflecting on it. There has been comments raised in terms of, and I'm just putting this, and I'd like to put it to you, but also the commissioners as well, and the deputy chairs. The comment has been made that if you look at particular other governance structures, you have a distinction between those who have executive roles and those who have line authorities for particular functions, as opposed to those who have non-executive roles. And the concept is that they can lift their focus, take more of a helicopter view with respect to longer term strategic issues, ultra direction, etc. But if you're in an executive role, perhaps you're less able to do that because you're more concerned with the minutiae and the operational day-to-day function. So I'm interested in your view, but also the views of the deputy chairs and the commissioners with respect to that point, distinction between wearing your non-executive hat in terms of certain oversight functions internally from a governance perspective, but then you're also wearing an executive hat, and how you manage that dynamic.
Okay. I think I will open it up to my fellow commissioners, but I'll have a short go at your question. Can I say at the very beginning, we're not a company, okay? We don't have shareholders, we don't have investors. We're not a company. And so very often when I have these discussions, which I find absolutely interesting and very important for the agency, I just would like to remind everyone, we're not talking about a board of corporation that can be voted in and out by shareholders, that has the rough and tumble of commercial life, which brings with it all sorts of issues about, running a company. That's not us.
So you'd be
We're an
talking about an
independent-
advisory board then, wouldn't you, at best?
Okay.
Yeah.
Well, I still question what an advisory board can do.
Fair enough.
The reason I say that, I think Commissioner Deputy Chair Chester for this. I think she gave evidence earlier today about the 5 or 6 consultative panels. We must be among the most consultative agencies on the planet. We have a whole range of groups, panels where we try our best to be engaged and listen to the sort of input that people would like us to have. So I think even having an advisory board, I'm not sure what value that would add, given all the other panels and engagement we have. And I'll give you another example. This didn't come up this morning. I mentioned it in my opening though, and one of the key things that I'm working on with the Commission throughout my term will be the digital uplift at ASIC. And so that is a very important program for us. And I chair the steering committee for that, which is about to be formed, and we're going to appoint 2 external people to it. Because the digital transformation at ASIC is absolutely essential to our future. And yes, we will have consultants and experts, helping us along the way, but I'm actually going to appoint 2 prominent individuals outside of ASIC with demonstrated expertise and experience to help us get it right. I think the benefits of an advisory board, which I absolutely accept there can be benefits, I think they can be captured in other ways. Now, the problem with having an advisory board, if we appoint one of a formal nature, is managing conflict and independence. And we're trying to run the agency independently. But look, I'll stop there because I've sort of been at it for a while, and I don't know whether other commissioners, the Commissioner Deputy Chair Chester, but I'm sure has views about this, having spent a lot of her time in a previous review thinking about these issues. So I'm in the chair's hands. That's exactly how you want to do it.
Yeah, no, that's good.
So thank you, Chair Longo, and thank you, Chair, for having a dedicated session to this topic. And I had the good fortune of, before joining ASIC back in 2016, of working on an ASIC capability review, which looked at these sort of governance matters. Where we arrived at is effectively in that capability review, where I was joined by 2 other panellists, Mark Gray and David Galbally QC, and supported by a terrific secretariat from the Treasury, is we basically came to the model which ASIC has finally reached today. And it is a hybrid model, but most regulators do tend to have hybrid models. The FCA is slightly different. But domestically in Australia, our model is akin to that of APRA and akin to that of the ACCC. The way I view it today has sort of reinforced that after having had the good fortune to be appointed to this role and have worked at ASIC now for just over 2 years, is where the commissioners are different to the executive is everything we do is through a whole of ASIC lens, which is akin to what a board would typically do. But where a regulator is different is some of our role is, a lot of our role is decision-making, regulatory decision-making. And that requires absolutely no conflicts, but it's also quite time demanding to be able to do that. And that's where it's a little bit different from a sort of a separate board in a governance sense in the private sector. So in the past, ASIC didn't quite have that distinction. You had commissioners that were very dedicated to particular streams of work and endeavour, and there was a view that meant that whole of ASIC lens was being lost. And the model we're working with today makes it very clear that commissioners are very distinct from the executives. The executives report to the executive director's report to the whole of the commission. So there's that in itself is nearly sort of like an executive role, but it's not, because we're whole of ASIC, but it is very time demanding. And as Chair Longo pointed to, the other aspect is the outward facing. And that's another thing where commissioners dedicate a lot of their time to the consultation, the sort of meetings that Kathy Armour was talking about earlier today with external parties around the ASX and the CHESS program. So, but in a more traditional sense, where we are whole of ASIC, which might be considered to be closer to a board, is on the strategy, on supporting the chair to meet his responsibilities as the accountable authority, to make sure we have in place all the right policies and processes and procedures and governance and risk management frameworks. And so that's done by the commission meeting as a commission, and then we have the decision-making committees. So I think that's my way of saying it is a hybrid model, but it's a hybrid model that works. And I think that, coupled with the accountability layer that Chair Longo articulated through parliamentary committees and now the FRA, means that we've got that oversight occurring on a long-term, ongoing basis. I hope that.
Yeah, no, Senator Scarr, do you want to keep going? Or
I'm interested in the views maybe some of the other commissioners have, if they'd be interested in offering their views. I mean, you've been there a long time, and what Chair Longo and Deputy Chair Chester says makes sense. But if there are any other additional thoughts,
Well, I think we can go around the table. I might go to Sarah Court now, because she had all that experience of the ACCC and has now been with us as long as I have. So I'd be very interested in her articulation. And then absolutely we should go speak to Kathy, Danielle and Sean and get some impressions as well.
No, I'm very happy to talk about this, Senator Scarr, because in a sense I have the fortune of having been at the ACCC for many years and experienced the ACCC governance model and then come across to ASIC. I think for me, the delineation, I'm not even sure I'd describe it as a hybrid model, but maybe that's a matter of semantics. From my own perspective, so ASIC is now operating in the same way as the ACCC does in terms of its division between the commissioners and the executives, and the only divergence, if you like, from Chair Longo's comments that I would make is that while ASIC's been operating this way for many, many years, the transition from executive commissioners to non-executive commissioners has come about, so far as I understand it, post Deputy Chair Chester's capability review, but that is now completely implemented. And so I'm very familiar with it and very comfortable with it, and I actually think it's a very good model and works well. So I see myself effectively as a statutory decision maker. So I've been appointed by the Governor-General to be the Deputy Chair of ASIC, and I have a responsibility for decision making on regulatory issues. And to do that, I, with my Commissioner colleagues, sit around the table day in, day out as the executives and their team members bring matters up to us, kick the tyres, we test it, and we form our view as to, whether or not a particular regulatory guide should be issued, whether or not particular court proceedings should be issued, what the ASIC's overall strategy should be. And that's very much a full-time endeavour. ASIC has a huge number of matters on at any particular time, and we also do that external facing work as well that's already been alluded to. The speeches, the engaging with industry, the talking to the consumer groups, the bringing information into ASIC and being representative of ASIC externally. I personally don't have any direct reports. I don't have budget responsibility. I don't run a line of for example, my area of expertise is enforcement, but I don't run the enforcement budget. What I do is liaise with the executives. They bring matters to me. They might get some strategic guidance. I have no individual decision-making power. The Commission operates under the statute as a collective. So if we want to take proceedings against the Commonwealth Bank, I, as the Deputy Chair of Enforcement, have no decision-making power in relation to that. Myself, with my colleagues, collectively make that decision, and that's the value of a commission, because we all got different backgrounds, we've all got different perspectives, and we come around the table and we thrash these matters out. We take the advice and recommendations of our staff, we test that, we push back, and I think that's where good decision making happens as a regulator. So I'm very comfortable with that division. We have a slight removal from the staff and the teams that are doing the work, in the sense that we want to be a sanity check, a reality check. We want to kick the tyres. We want to say, well, that's all very interesting, using Deputy Chair's language of we look at the whole of ASIC issue. If a matter comes up to us through a surveillance or through an enforcement investigation, we want to make sure that what we're doing is not inconsistent with the work the Commission's doing in other areas. So for my part, it's clear and it works well. And I think we, based on feedback that certainly I'm aware of since I commenced in the role, we have some work to do to explain externally how that model works and why it works, because we have had feedback that, for example, that stakeholders are not clear where decisions are made within ASIC, as an example. And I think, Joe and I and the other commissioners have got a job to do to be engaging with stakeholders and the external community about that. And the final point I'd make is, coming from the ACCC, one of the things that is I was unaware of when I commenced at ASIC is the extent of oversight of ASIC. I thought that the ACCC had significant oversight. I'd say ASIC probably has at least 5 times more oversight, in the sense of the number of parliamentary committees that we attend. I think in the first 2 weeks that I've been back from leave, I think ASIC's appeared at least 5 times in the fortnight. Now, I'm not complaining about that. All I'm observing is that there is a lot of accountability, in my view, through that process quite properly, and I think the engagement with this committee is constructive and of great assistance in relation to the things we need to think about. But we also have oversight, of course, as Chair Longo mentioned, from the Ombudsman, from the Commonwealth Law Enforcement Integrity Area, from the courts themselves. When we get it wrong, the courts are quite quick to point out where ASIC's got things wrong, and of course from the media, who, again, we are accountable to quite properly and have no hesitation in pointing out where they are of the view that we have made errors. And then finally, just in the conversation about an advisory board or any other external board, I am very much of the view that would be not of great assistance to ASIC, not least of which because of the conflict issue. And if you started to have industry representatives overseeing ASIC in any way, you would then need to have representatives from a number of other areas like consumer groups, financial advisors, the entire range of the community which we regulate. And really the FRA is doing exactly that job. I mean, the FRA is a new being. It's not something that any other regulator that I'm aware of has in Australia. So APRA and ASIC uniquely, I think, now got this additional level of oversight, and our engagement with that body has been extremely constructive and very helpful. But I would hope that we see how that process works, see what the outputs of the FRA are, certainly before we started thinking about any other additional model. So those would be my comments. Thank you for indulging me.
Just before we just go round to any other commissioners who are interested, that's helpful. You made a really important point there, I think, about the level of oversight, and if I can just, I think that's an important point for us to consider in our report. It's unique in a sense that, I mean, we are your oversight committee, but because of the breadth of what you do, the economics committees take a big interest in you. Everyone has Senate estimates, and this oversight committee meets more regularly. I mean, a good example today would be the House Economics Committee that have had a big interest in some issues with you, the Senate Economics Committee. I better not leave that out. But you take the Reserve Bank's up before the House Economics Committee today, and it's really a cultural thing within the Parliament because it was officially part of the Independence Compact that was reached. That's where they go. they certainly appear elsewhere from time to time, but it's a couple of times a year generally. So you're at more committees more often, and this one you're meeting several times. So I think that is an important point for us to make in our deliberations. I mean, the real purpose of this discussion is, I think Chair Longo hit the nail on the head. It's notwithstanding all these reviews that we're well aware of, that pretty regularly someone comes up with this new old idea. And so being able to explain it a bit better is really where I'm coming from, I suppose. And if, I'm not advocating. If I was advocating it, I'd do what a lot of my colleagues do and write an opinion piece about it. So, but I just thought it'd be better to have an informed discussion. So we're going to go to Mr. Hill in a second, because he and I had a chat earlier, and he'll broaden the discussion a little bit, and we've got Treasury on the line as well. So I think you'll find a way to work that through.
To go to Treasury too.
Yeah, that's right. So, but just without us all saying the same thing, I mean, I think it'd be helpful if we just heard from Mr. Day for as long as he wants, given he's responsible for the executive, if that's okay. And I suppose if you agree with everything that's been said, just say so. If you've got another perspective, it'd be handy.
Thank you, Mr. Smith. I think I'd agree with everything that's been said. I think in terms of, and it's per the capability review that now Deputy Chair Chester chairs, that there's a need for a COO/head of office role, and ASIC's done that. And effectively that role's been in the structure now for not that long. It's actually really only been about 12 months. And, through that, the phrase I would use is, we're still transitioning. I think we're a long way down the path, but it's something where, the existing executives, the existing commissioners, we have changed in terms of that, strategic decision-making and setting by the Commission, and the executive taking ownership and control of those organisational and operational matters. We are well down the track on that. And we've put the governance structures in place in terms of our internal executive committee, to ensure that effectively the Commission is on a decreasing to the point of not involved in operational matters, and so effectively that's being set through the executives. I guess the one thing I would say is then there are some things that we can't get away from, is that in the way that the PGPA Act works, Chair Longo is the accountable authority for ASIC. So for all financial matters, that cannot be changed. But in fact, the way we've dealt with that is there's a large delegation of financial powers to myself, so that effectively I have the ability with the executive directors to deal with the majority of those larger operational matters from a financial perspective. But at the end, the financial responsibilities and accountability still rests with the chair, and that's the way it should be. So those things are still there, but we are outside of that, moving and have nearly finished moving completely to the fact that it's the executives that are effectively running the operations of the organisation. As Deputy Chair Court said, we can then bring those regulatory decisions, those key enforcement decisions, to the Commission to make those decisions. But the other things in terms of the day-to-day operation running of the organisation, it's for the executives. That wasn't the case before. They were still finding themselves in the hands of the Commission. So I think, as I say, we've transitioned from that. We're finalising that. As I said, we're about 12 months down the track. And we're in good shape in relation to that.
Okay, no.
Chair, it's Sean Hughes here. I was just wondering if I could jump in. I haven't spoken yet today,
Yeah, sure,
and
absolutely.
For purposes of Hansard, Commissioner Sean Hughes. I just wanted to say that I've had direct experience with a board model, and I thought for the purposes of the committee, you might be interested to hear in that, if I can just give you a few minutes of my time. Like Chair Longo, I was also a senior executive at ASIC before I was a commission member. But in 2010, I was appointed to establish and then lead as Chief Executive for the Financial Markets Authority of New Zealand. And that agency, which is ASIC's peer agency in New Zealand, has a board model. And the board there is comprised of 12 non-executive directors appointed by the Minister of Finance. And it's a board that is intended to represent the diversity of the markets that it regulates. And so in my time as Chief Executive, we had directors who were experienced company directors with deep-seated blue chip experience. We had a member on the board who was a director of the local market operator. We had professional accountants and lawyers. And then at the other end of the spectrum, to represent the diversity of the market, we had a financial journalist and we had a shareholder activist. Now that made for very interesting discussions between the executive and the board. I'm not going to sit here and say that one model is better than the other in the context of a much smaller market economy of the size of Victoria, and with a smaller mandate that the Financial Markets Authority has relative to ASIC. It may well be appropriate that a board model is better suited, but I would call out that, of course, other jurisdictions do have board models. Mr. Longo's already referred to the UK, Hong Kong being another example. I think there are opportunities with a board to be clear around the delineation of responsibility, executive responsibility between the executive and directors. In the context of New Zealand, the board members held certain decision-making authority to themselves, and that was not delegated, and that generally related to obvious things such as the appointment of the chief executive, but also important regulatory and enforcement decisions could only be made by the board and not by the executive, obviously on advice from the executive. So the point of my intervention, Chair, and I'm sorry if I've taken up time, is simply to say there are other models. Some of those models, such as the New Zealand model, were based on a close consideration of options at the time they were established, and they were decided as best right-sized for that particular economy, and have subsequently been endorsed by international monitors. But I can assure you that as a Commission member of ASIC, I'm fully supportive of the model we operate under, and I think Deputy Chair Court expressed it very well.
No, thank you, and thanks for jumping in. We'll now go to Julian.
Sure.
And we'll be bringing Treasury in fairly shortly.
Sure. I might, having listened to the discussion, find it interesting. Partly the public sector administrative nerd in me finds this stuff interesting because we do deal with it in the Public Accounts and Audit Committee from time to time with the Auditor General. But I might just kind of summarise a few of my thoughts and put them on the record and invite you to comment on those. And then I've got just a couple of specific questions. But I think the discussion around conflicts is apt. My view, having looked through the summaries of the many previous reviews, and I think the Chair said this is an old idea that keeps coming back like a boomerang. My view is that the current structure makes perfect sense, and I think that there's far more problems that would arise with a board structure than the perceived problems that it would solve. I suspect part of it, from looking at where the idea keeps coming back from, is either politicians not perhaps appreciating, because it is a very rare beast, the real complexity of what you do and the fact that it exists in a public sector context. And I've seen this in many discussions in public accounts and audit, that people who've never had any experience of the public sector import, for understandable reasons, private sector concepts and try and apply them in a public sector context, and it sometimes just falls over. So I think those other two elements which the previous reviews have highlighted are worth just putting on the record, which is accountability. I think Chair Longo observed you're not a private company, and the accountability back to the Minister and Parliament is particular to the public sector, where your authority flows from. A board may well confuse that in this context, given your exercise, the kind of statutory powers you exercise, and also that sense of independence. Much as you can manage conflicts, it's ultimately going to be very difficult to manage perceptions that you're responding too much to particular board members and the inevitability that they will try not necessarily for personal profit reasons, but they will try to influence things in a particular direction, given their experience or sectoral interests, even if they're not direct narrow conflicts. So I think there's those influence issues which are, you can't deal with them through conflicts. You just have to accept them if you move to that model. Conversely, I think that you've well outlined the fact that there's many other mechanisms in place and which can be called upon from time to time to get the perceived benefits from the board. Your stakeholder and market engagement can keep you in touch, your staff capability and so on, and as has been recorded, the FRA gives a very formal now and permanent institutionalised mechanism to keep reviewing your capability and your effectiveness. You're accountable in that new way there, and that's a very formal and regularised mechanism for people who have concerns with you, big or small, to actually take them up, knowing that there's someone watching the watcher. And from time to time, and no doubt you do this, Chair Longo and Mr Day, you can invoke external reviews that can either be done by you or Treasury can do them to you from periodically. So I feel comfortable that the perceived benefits can be got in other ways without picking up the negatives. From listening to what you say, that shift towards a more to misdeploy, if you like, the board management model, but the shift more towards a board and management model makes sense. In passing, I'd just note that a better parallel than a private sector board may actually be more like a local government. I was a mayor of a council 20 years ago, which was another story. But it strikes me very much that what you're describing, you're trying to now set up and make work, is almost like a local government where the commissioners are the council, the difference being we have an executive mayor who straddles two hats, whereas in a traditional Australian local government structure, the mayor is not an executive. So that's a model which I can get my head around as being very familiar, because local governments also operate under very complex sort of legislative requirements that are exercised collectively by the council, collectively by the commissioners, setting policy and delegations and so on, and then making decisions on big things. It seems perhaps a better analogy. Anyway, I'll sort of put that there, happy to be corrected or steered in another direction, given that's the nature of the discussion. But the couple of questions I'd put that I'm curious to explore are, in another governance sense, the interaction between ASIC and the Department of State that loves you and lives with you, being Treasury, and to ask the question in a different way around us as an oversight committee, and we do this periodically with the Auditor General in public and private and through the formal legislative review for the Public Accounts and Audit Committee, what is expected of this committee when it's operating well as your oversight committee? What in your view and has attention been paid to that oversight committee entity relationship in this space? It's Senator Scarr and I nerd out on the Audit Committee periodically, and I think it's an issue which we've explored much more explicitly, and it's much more institutionalised, frankly, having been around since 1901, as to what that relationship is between the Parliament via the Audit Committee and the Auditor General versus ASIC and this committee. So I just sort of put those two topics to explore there now, the relationship between Treasury, and invite any other comment. Sorry for the monologue.
I'm not sure, Chair Smith, how you want me to approach that, or...
I'm sorry, I was just briefly out of the room.
The Chair obviously agrees with everything I said.
Well, that'll be a first. So why don't you say it again?
No, I'm not saying it again. No.
I think there were two questions. I really, just in the spirit of dialogue, I think there was one question addressed to how ASIC works with Treasury, I think was one question. Yep. And the other question, which I think is an interesting one, and I've never been asked this before, and if I can get this right in one, what you think, we think you as an oversight committee should be doing. What is the...
Well, perhaps I'll put it on the table as a topic rather than putting you on the spot, but it's a topic which we explore periodically in Public Accounts and Audit, and it's quite an institutionalised topic.
Yep.
Yeah.
There's this thing called the Australasian Conference of Public Accounts and Audit Committees and Auditors General.
Yeah, I'm well aware of it.
Yep. I've spoken at it a few times. And it's a topic that jurisdictions explore together. How does the oversight committee work with the independent auditor general, and I think it's an interesting topic. How do we do our job effectively on behalf of the public in a way that's productive and rigorous, not needlessly antagonistic, but also comprehensive, rather than just turning up with interesting newspaper articles that we've read that day.
And this is a discussion. This is a discussion. So I mean, in a discussion, you're always welcome, of course, to say, here are my initial thoughts, but I want to give that a bit more thought. So in doing this, it doesn't mean after today we can't continue the conversation.
Well, look, I'll make some very short remarks, but I'm really interested in other people's views, Greg Kirk and my fellow commissioners. The institutional relationship we have with Treasury is of the utmost importance for the administration of the legislation and for ASIC. It's so we work very closely with Treasury. There's a whole range of touch points. We're constantly reviewing. In fact, I've just recently reviewed optimising how those touch points work so that there's good communication, things get done. There's a Treasury Secretariat, of course, that supports the FRA, which makes that connection with Treasury even closer. And for the government of the day, there's a whole range of issues that come through Treasury. We work together to sort them out, don't always agree. It is a really important institutional relationship, and one that all of us, all of the Commission really think about to be able to do it independently. As far as the Parliamentary Joint Committee on Corporations and Financial Services is concerned, I think your committee, with great respect, has a really important role to play. We have a very broad jurisdiction, a very broad remit, and any insights or feedback you give us, we may not always agree with it, I might add. In fact, time to time, I've been known not to agree with some things. But that's the way it should work. We in a liberal democracy, you're there to represent the Parliament and the people, and I think from my perspective, it's an open conversation we can have. But I suppose in the end, it's a little bit like the work we're doing with FRA. We do have a very complex jurisdiction. The law's constantly changing, resources are stretched. There are a whole range of expectations of ASIC. We can't meet all those expectations. There are choices we have to make all the time about how we use our resources within quite an elaborate governance framework, the PGPA Act, among other things. So this committee, there's a key role to play in how we navigate all that. What should we be doing? And that's it. So I'll open it up after that.
Yeah, well, I feel validated and comforted by that and reassured of our status and place in the world. But if anyone's got any specifics as to, how we go about our job, are there annual cycles, are there things that could be institutionalised? I just think there's a little bit more of that in the audit space, and you've been a chair of the audit committee.
Yep.
There's certain annual rituals that come to you, and there's certain topics that you turn your mind to. And it's just been developed over a century or more.
I'm open to suggestions about that. I'm to be frank, I haven't really given this.
We could review ourselves.
So I'll open it up to everyone else.
Chair Longo, let me give you an example of perhaps what happens at or one of the issues that my friend Julian Hill and I, MP, and I have pursued at the JCPAA, and that is, and this might be a gentle lob for you to hit over the square leg boundary, but one of the issues has been the budget of the Auditor General, to make sure the Auditor General in discharging his role, the ANAO in discharging their role, are properly resourced, because if they're not properly resourced, then they can't give appropriate attention to all the matters which they should be giving appropriate attention to from a public audit perspective. So we actually formally consider the budget submission which the ANAO makes to the government, Treasury, each year. Now, I'm not proposing we do that.
Just to cut you off for a second, Senator Scarr, just in the interest of clarity, because you're on the committee and I chaired it many years ago. It's a very important point Senator Scarr's making, and it's still not widely known, even by members of Parliament. I think Mr Hill will agree. Members of Parliament haven't been on the Audit Committee. That not only is there that oversight of it, but on the day of the federal budget, at around about 4 or 5 o'clock before the budget is produced, the chair of the committee is required to stand in the Parliament and report on whether the budget is satisfactory or not. And in fact, they need to report that it's satisfactory, and so all that goes on before the budget. So there's quite a formality to it. I think it's fair to say that's lost on budget day with everything else going on, but it is an interesting model, and it's part of the independent structure that's been there all along in a very formal sense. So I think I just wanted to add that, Senator Scarr. Sorry, just.
So I guess from my perspective, it rose tangentially during the Sterling inquiry, Chair Longo, when you refer to all the other matters ASIC had on and your capacity to deal with all the issues that ASIC has to deal with. So just comparing the other committee, we had the same discussions with the Auditor General in terms of competing priorities and what resources the Auditor General needs in order to undertake that key function. So I only raise that as an example of one of the things we do in that capacity.
Yes.
In my short time on this committee, we haven't really discussed and maybe it has been discussed in the past in relation to the resourcing of ASIC, etc.
No, that particular question is obviously very fundamental. I mean, I think I mentioned earlier something that I've had to learn about coming back, because it wasn't like that in the 90s or the early 2000s, is the industry funding model for us. We're industry funded, so largely industry funded. And so there's but that's actually under review now about how does that fit in with how this committee might engage with that fundamental question of, well, what sort of financial resources or budget should ASIC have? And obviously FRA's now on the scene, and what's running through my mind as we're speaking is funding, for example, for digital transformation. That's a significant investment. We're working through that early days, working with Treasury and others to see what that might look like, and so that we're a year away from really landing that. But that's a good example of how's that going to work if that proposal. But I'd like to hear from others. I don't know whether Deputy Chair Court or Chester or Sean or Kathy or Danielle wants to jump in there, but as to both questions. But if the committee is thinking about being a bit more ambitious, if I can put it that way, as to how you could engage with ASIC to good effect, then I'd like to take up the chair's invitation to think about that a little bit.
Yeah, I mean, just before we go to the others, we certainly want to hear from them, and then I know Mr Hill's got some Treasury related questions that you'll.
Well, I can't put them there, but we can invite Treasury's comment, and I'm
Sure.
curious about Treasury's view on those issues.
Yep. No, that's fine. I mean, when you mentioned the the digital transformation, obviously that's critical in an agency like yours. You're not the only agency or organisation contemplating that, but my immediate instinct is it'd be far better with an oversight relationship that's productive, proactive, but by no means an agreement factory. That the committee that'll be the next committee that I'm not part of, obviously, was aware of the scope of the program, had assessed it, and essentially endorsed it, even by way of a private report, if there was any reason for that to be the case, rather than picking at it after it's being implemented, where there's the chance you'd be stuck saying, well, we would have done other things if we had more money. So, I mean, as well as being a critic, the committee can be an advocate, and essentially that's that's why that's an excellent example of Mr. Hills about the audit committee. I mean, there's always the priorities on what's audited and what's not, but the committee can obviously be critical of departments once those audits are public, but they can be critical of the way the audit's been approached, and that's happened.
Yeah,
that's happened before. I mean, certainly when I was chair, it happened on a handful of occasions where the way the language was expressed really wasn't fair, I didn't think, to some of the departments in terms of how they were implementing those. But over and above all that, critically, you can wear a number of hats. That committee really is an advocate for independence, and
most days.
Yeah, most and certainly in its budget. So when you mention the digital transformation, I mean, I think it would be very much in everyone's interest where you're undertaking a big project like that.
Yeah, the other thing the committee does, just to stick with the parallel, there's a fundamental difference, just to put on the table so we don't go too far down that path, that the Auditor-General works for the Parliament.
Yep.
The Auditor-General exists to audit the public sector for the Parliament, is an officer of the Parliament in effect.
Yep.
And that's the reason for the very formal budget process, to make it very difficult for a government to nobble the Auditor-General by cutting the budget.
Yep.
So it's a traditional mechanism. It wouldn't be an equivalent thing, so just put that on the table.
No, absolutely not.
But my thought's gone after that little path. That'll be the 5 a.m. finish the other night.
It would be.
The other thing we do, though, is we engage formally and have a formal role in the appointment of and the priorities of the independent auditor of the Audit Office.
Yeah.
And that's just another sort of thing to think about and explore if we wanted to perhaps put a little bit more rigour or flow in our annual deliberations for future committees, to give some thought to who are your auditors, looking at your risk profile, and periodically, not all the time, having a sense of your resourcing. We've got Fra now to talk to about capability. That's just my observation in my time on this committee. I think we do some really interesting and useful things, and the public discourse is important in itself. But sometimes we could, have a bit more structure so we don't just divert into chatting about what we read in the Fin Review that day. Although, did I mention the proxy advisor thing was abolished? And
you did, and that's not the 5 a.m. thing.
No, that was yesterday. We talk about that again.
Can someone else just jump in? That'll be helpful.
Chair,
Thanks.
perhaps I could
Thanks, Commissioner.
quickly-
Thank you.
Perhaps I could provide a quick supplement, which I thought might be helpful here. Rewinding the clock 5 years ago when the capability was done, it did actually make an assessment of the oversight role that the parliamentary committees were making towards ASIC, and that analysis did suggest that there was a greater degree of short-termism in the issues of the day that were being addressed and being put to ASIC, as opposed to some of these more sort of medium to longer term slow burn issues that you're now raising. The fact that we're having the discussion today shows how far it's evolved during that 5-year period. And I think from our perspective, the one thing that I'd say is when we did the capability review, we didn't think something like the FRA was a good idea, or a regulator to regulate the regulator. But that said, the way the FRA has been crafted is actually taking that medium term to longer term lens, looking at the capability and the ongoing effectiveness of ASIC, and that provides fertile ground for this committee to draw upon as we sort of try to evolve with better performance measurement, better prioritisation, and Treasury supporting that on an ongoing basis as well. So from our perspective, being able to step away from the immediate short-term issues of the day with this committee and to deal with issues like digital capability, are we making the big calls on strategy right, and getting that spirit level a little bit better is where we're heading now, and where I think the FRA will be able to support the committee as well.
No, that's good. Let's keep moving. Anyone else? Sarah or?
I don't have much to add. It's suffice to say, certainly not on the formal regular engagement that you're talking about. I think that's very worth thinking about. In terms of the relationship between ASIC and this committee, and I'm fairly new to it, I find the nature of the hearing this morning very constructive from that perspective, I have to say. For example, Mr. Hill, the questions about the Section 19 notices and the Section 22 issues, I think it's very helpful. I assume that you have had feedback in relation to some of those processes, and I think this is the way that you've raised those is very constructive for us to go away and have a think about some of those issues. And so I think the committee members will get feedback from our stakeholders that perhaps don't make its way through to us on occasion. And I just thought the nature of that engagement and the way those issues were raised, certainly from my part as having a lot of responsibility for the enforcement side of the work that we do, very helpful to hear those comments, to hear those questions, and then perhaps we can go away and have a think about those issues. So for my part, the nature of that exchange is very appropriate and exactly the sort of things ASIC should be being asked about in relation to the exercise of our powers. So I was just going to make that observation, Chair.
Okay, no, thank you.
I'm satisfied. I just don't think we've heard from Treasury.
No, so can we hear from our Treasury witnesses on any, well, first of all, just on the relationship with ASIC generally and on the issues we've been talking about?
Thanks, Chair. For Hansard purposes, Mahita Zahid, Assistant Secretary, Financial Systems Division. Listening to the conversation and waiting for a Skype in, so thanks for inviting Treasury's comments. So in terms of the relationship with ASIC, I might start there and then go on to some of the other things we've talked about. I think we've got a very, as Chair Longo started off saying, we've got a very deep and broad relationship with ASIC, both from the role we have in terms of advising government on policy matters in relation to things like, providing advice, managing processes around appointments, but also fundamentally, and where it really comes in, is around giving advice to government on issues in relation to corporations, financial system, all the stuff around auditors, insolvency, so the breadth of ASIC's mandate falls in different parts of Treasury. So we rely very strongly on ASIC for advice. And ultimately ASIC has to implement the policies that government and parliament puts in place. So that relationship is quite strong. We have, as Chair Longo indicated, recently refreshed that relationship to ensure that both Treasury and ASIC weren't losing sight of the bigger strategic discussions amongst ourselves in the day-to-day. So there are quarterly meetings that happen at senior levels between ASIC commissions and senior officials within Treasury. So we have similar discussions around the broader strategic direction of ASIC, how ASIC is prioritising, and that's all within our role to advise government and make sure that portfolio ministers are getting that best advice. And obviously the FRA is a new addition, so it's my team that heads up the FRA Secretariat, and that is really creating an ability for us to have that longer term benchmarks and consistent view around ASIC's and risk performance over time. So I think it's a very intense relationship at times. There's a lot of times where we don't agree. There's a lot of times where we agree and Parliament and government may not, but it's a very constructive and productive relationship. So I might stop there in terms of the nature of the relationship. We can delve into some of the systems and processes we have in place if that's of interest. But I think the other question that has obviously been discussed is what's an effective use of this committee's time in relation to ASIC, and it's obviously very much one for Parliament to figure out with ASIC. I do think the work that the FRA will be doing and the way the FRA has set itself up, which is very much looking at different aspects of the regulators over the biennial review cycle does provide, hopefully, that long-term view. We've had previous capability reviews, but they've often been ad hoc. But having that long-term consistent methodology should hopefully provide a bit of a longitudinal data set for this committee to use, as well as other members of Parliament. But I might stop there and kind of very happy to jump in with very specific observations. Could speak, waffle on about this for a long time, but I might just see if there's specific areas you want to delve into.
Oh, well, I've just got a couple. I mean, in terms of the close relationship, this might sound unrelated, but it's just giving us a window into how that relationship works. Got no doubt that you're working very closely and talking all the time. I'm just interested, I suppose, whether you've got the latitude and the capacity. I mean, ASIC come to Canberra a lot. They'd be here in person if it wasn't for the restrictions. But in terms of having a deep dive on a few issues, I mean, does Treasury ever go to ASIC? It's headquarters out of, to go to Sydney or Melbourne and see firsthand what they're actually doing, and because I think sometimes I raise that not as a, in a critical way, but sometimes the relationships I know, very generally in this town. I mean, Parliament's sitting, it's very emails going to and fro. Do you get to know each other? That's the...
Chair, that's an excellent question. So up until a couple of years ago, we used to, so Treasury has an office in Sydney, we have an office in Melbourne,
Yep.
We also have an office in Perth. Up until a couple of years ago, we were co-located in the same building as our ASIC colleagues in our Sydney office. That's shifted because we've grown. There is a lot of, up until COVID, which has obviously changed the dynamics for us all, a lot more of it is in VC. We tended to, so we do have regular strategic meetings, which are much more at the Commission, Deputy Secretary, Division Heads level. We tended to try and congregate in person to build those relationships, to make sure you were sitting across the table from your ASIC colleagues when you were having those open conversations, and we'd kind of rotate. That's changed a little bit, unfortunately, because of COVID, and it has meant everyone's geographically dispersed. We also have, in terms of that relationship and getting to know each other, at more junior levels. At a senior level, there's a lot of very detailed, very good, very robust conversations, some of them very challenging. At more junior levels, we have an effective secondment program between ASIC and Treasury, for example, where we can import in expertise from the regulator. They get to better understand how Treasury operates. And then what we have are systems and frameworks in place to ensure those conversations happens. We've got a regular committee meeting where ASIC and Treasury sit down to talk about the legislative program, for example, to make sure those elements are flowing through effectively. We have quarterly strategic discussions, and then at every level below that. So there's a lot of investment between Treasury and ASIC to ensure we've got the relationships in place, not just to collaborate on technical details around how this particular piece of law works out, but where we can disagree and we've got the confidence in each other's relationship to have robust and conversations and make sure we can hear each other as we do it. That's my personal reflections. I would be very keen to get those similar kind of reflections from my ASIC colleagues who, as always, are free to disagree.
Thank you. The floor's open to anyone, or we can go to Mr. Hill.
I think that was actually very helpful, and the FRA...
Kirk, I think, wanted to say something. Sorry.
Yeah. Yep. We had a first date with FRA yesterday, didn't we? I think we'll have more dates.
Yeah, hang on. I think, who wanted to say something?
Sorry, Chair. It's a bit awkward in these circumstances, but Greg Kirk, who has a lot to do with Treasury over many years, he wanted to make a contribution, if that's okay.
Yeah, no problem. We can just see you, Greg. You've got a halo around you with the light, but there we go. That's better.
That's a very misleading halo, is all I've got to say.
You need your microphone on, Greg. You.
I
That's
would
better.
agree with everything that Mahita has just said, particularly on the legislative policy side. The relationship has been particularly intense for the last few years, just in terms of the scale of the program of reform going through, and that looks like continuing for a while. I think through that, we've had an enormous amount of contact. I think the refresh of the structure lately, in terms of a clear range of committees beneath the sort of quarterly liaison that the Commission's involved in, has, I think, is a very positive development in terms of making sure that relationship is structured, that for the scale of the work involved that's done jointly, we need those structures. And it also supports both organisations knowing and being able to navigate where to go in the other organisation in terms of particular issues. So clarity around that, clarity around making sure there's no mistake, that as to, I spoke to two different people in ASIC and I've got two different views, trying to avoid any of those sorts of situations. Clear about points of escalation, so that if there is situations where either side is feeling we're not being adequately heard by our counterparts, that there's a clear process for escalating that and a way to do it. And that committee exists for that purpose. It's not saying escalating things is a bad thing. It welcomes the identification of issues that do need to be escalated for further discussion at a higher level. We've also involved, I think the last couple of years, and certainly it's going to be an ongoing thing, Treasury earlier in our thinking for our own strategic planning, in terms of sharing with them our early thoughts on what our strategic priorities might be, and getting feedback from them. And it's another way that we get feedback in that strategic planning process, and has proved so far to be a very useful one. So I think the relationship at an interpersonal level has, I think generally been good in the long term, but I think the greater clarity in some of the structures is also welcome and in supporting good working relationship.
No, thank you, and thank you to Treasury for the comprehensive answer. Look, we've got about half an hour left. Certainly, from my perspective, I've covered certainly the governance issues, so that we've got some very good field evidence there for us, and it's good having Treasury along. I mean, one of the reasons we asked you along is you do have such a critical role, but you haven't been before the committee really. So I think we'll find that'll change into the future. I hope so. Anyway, that doesn't mean they need to be at every meeting, but certainly just this discussion's been very useful for the committee members that are here. So I know Mr. Hills.
Yeah, we said while Treasury were here if they were able to just clean up a few things from the previous questions on notice, but I'm not sure whether Mahita is able to do that or not. It's on the CDDA scheme and the interaction with ASIC's legislation.
So what you could do is Mr. Hill will sort of raise these issues and just hang on one sec.
Yeah, I think you appeared before us a few months ago. Is that right, Mr. Heed? I think there was a lawyer there as well, maybe.
Yes, Mr. Hill, it was me and Mr. Simon Reiter, who heads up our law division within Treasury.
So look,
I'm happy to take
I'll give you the floor.
questions. Sorry, you go, Chair.
Yeah, and I'll give you the floor, Mr. Hill, but we'll recognise that not everything might be possible given she came here under the governance, and even if it just means you're able to take those matters on notice if you need to, or if you need to consult with other people. We appreciate that as well. So, Mr. Hill, we'll go to you.
I'll just note at the outset that I appreciate, firstly, the response regarding the authorisation issue. That was a response which made sense, and I've made my view clear to people who have a different perspective that if there's uncertainty around that, then the only prudent thing you could do in the public sector is to presume that the authorisation has lapsed and proceed accordingly. You can't responsibly make decisions if there's doubt over that. The two issues that I just wanted to explore a little further are, firstly, this view that the Treasurer can't now delegate authorise ASIC to make decisions under the CDDA scheme. The questions on notice from ASIC, you'd note, outlined a range of previous decisions and monies that had been paid over some years. Is Treasury now saying that that authorisation was invalid and that those monies could not or should not have been paid? That's the only logical conclusion I can reach.
So, Mr. Hill, I will have to take those questions on notice simply because I'll need to consult with our legal colleagues. It's not the area that I specialise in. I mean, the point we made previously, and just for reiteration purposes, is we got to a point where we looked at this and best advice we have is the Minister could not authorise ASIC, therefore that authorisation was not remade. But in terms of the implications in relation to prior ASIC decisions, we'll have to come back to you on notice. I'll need to talk to the team within Treasury that has that response.
Okay, if you could. I mean, the response is clear and I thank you for it. It's not beating around the bush. You've stated a position and that's nice. Wish some other agencies would do that. Sometimes your position is that the application of the CDDA scheme is inconsistent with Section 12.3 of the ASIC Act, which defines the Minister's powers of direction. Well, maybe I'll just read some questions out on notice, but if there's anything we can deal with on the way, that would be helpful. So if you could confirm and ASIC could confirm that your position is that Section 12.3 requires ASIC to act independently of the Treasurer's direction. I think that was established last time, but if you could confirm. Can Treasury acknowledge or confirm that the relevant precursor to Section 12.3 of the ASIC Act was Section 12.3 of the Securities Commission 1989 Act, and that the sections are effectively in the same form? And can Treasury acknowledge that the explanatory memorandum to the Australian Securities Committee Bill back in 1988 provided that under Clause 12 the Minister would be able to direct the ASC, for example, to have regard to any relevant policies of the Commonwealth Government? I should say, sorry, I should have said this at the outset. My concern here is that without action, either to have a further look at it and reach a different conclusion or take legislative action, we've reached a situation where a major entity in the public sector is now outside the scope of the CDDA scheme, which just seems to be a nonsense. And if that's your position and it's interrogated further and it stands, then it's something that we could look at a legislative remedy, because it just doesn't seem acceptable. ASIC's repeatedly asked you, as they've acknowledged, for the authorisation to come back over some years. It hasn't. And it just seems unacceptable to me that taxpayers, entities, people in Australia aren't able to make a CDDA claim against ASIC in the way that they can against just about every other government agency.
And appreciating there are some very specific questions going back a long way, and Mr. Hill's clearly just wanting to read them into the record.
Yeah.
And we're assuming you'll need to take them away, but if you can also take away that it's a concern, obviously, of members of the committee, and it certainly might well be that we just follow up separately with a hearing, Mr. Hill, or something. Something separate in that.
Maybe the quickest way to deal with this is if I send some supplementary questions on notice.
Yep.
If you could have a look at them, and maybe we could just organise a half-hour, 45-minute teleconference as a subsequent public
Well, we
hearing
could
with Treasury on the
even
topic.
potentially do that at the time of our private meeting next week. I know next week's going to be busy.
No, next week it's Senate estimates.
Oh, next
Of
week. Yeah, we
course.
can't do that.
Yeah, of course, it's Senate estimates, yep. Okay.
Yeah.
Good point. Well, we'll come back to you, but we are indicating that we would like to have, just some face-to-face time on this.
Yep.
And in reality, we will end up doing it by Teams or Zoom or something when we're not sitting. We won't.
Yeah, I think that's a better way to do it. But look, that's my point that remains. I'm not trying to have an endless, idiotic legal fight. If that's ultimately the position you take, and I just want to interrogate that and check that it's robust, if that's the position you take, then it just seems unacceptable that remains the case that ASIC's outside the scope of this scheme. It just seems unfair to people that they can't access this scheme like they can against every other public agency.
So, we know you're all busy next week with estimates, with not just appearing but the preparation. So we'll have estimates. We'll give you a bit of a breather, and then we'll
Good. I'll get you some questions next week. I'll send them through the Secretariat. Is there anything else you want to add on that, Mr. Head?
No, so Mr. Hill and Chair, obviously very happy to have a separate discussion. I think that'll be much more constructive than trying to do it on this forum. One thing I would flag is obviously the Department of Finance owns the CDDA framework as far as government goes, and they have the Resource Management Guide 409, which is the basis of how the scheme operates. So if we are having a discussion, I think potentially bringing our finance colleagues along may be constructive. So,
No, that makes sense. I'd just note that ultimately any legislative fix would affect a number of acts like yours, because we were told the basis, the authority for this scheme flows from the Constitution, I think Section 62, the executive power, not from any legislative thing. So it's not a matter of finance amending their legislation. The non-corporate entities which may be barred from this, you'd need to have a look across government, but you're the one that's sitting in front of us at the moment that I'm most concerned about.
No, that's an important point, but I still think it's valuable.
Yeah, agree. Completely agree. Let's do it in a different
so
way.
much gets lost in translation between departments. It's better to get everyone together. Look, this has been useful. Has anyone got any other discussion topics or questions? Because, I think that this has been a quality period of time for nearly an hour and a half, and unless there's anything new, we don't want to repeat ourselves till 3 o'clock. Senator Scarr, have you got anything new?
Nothing new from me, Chair.
You'll have new stuff in estimates next week, I'm sure.
Well, on that note, look, Angie Bell's had to go off to an appointment. She let me know. The Deputy Chair looks relaxed and satisfied, but that's he does most of the time.
John Howard's Australia.
Mr. Hills mentioned the financial view as often as he needs to, so I think
can go again.
And no, I just want to thank you. I hope you found the way we've gone about this productive. I think we certainly have, and breaking the day up into the two sections I think has been good. It's given everyone a bit of certainty, and yourself, Mr. Longo, and your team some certainty. So thanks for that. There's a few follow-ups, but I think the way we went about it, there's a lot less than normal, because a whole lot less needed to be taken on notice. So thank you very much. I'll need that closing statement, won't I? Just so that whereabouts are we? Okay, I've just got to officially read this statement, as you're well aware. Thank you for appearing as witnesses today. Answers to questions taken on notice should be provided by Friday the 4th of March. That concludes the hearing, and again I thank everybody, and also thanks to Hansard and Broadcasting, and the committee is now adjourned. If we can switch off the broadcast.